May I beg your pardon to mention, my lord? It's a juvenile bail matter, my lord. Listed there. May I please, your lords? My lord, Criminal Appeal 1359, the appellant has been convicted under section 7 and 13(2) of the PC Act and has been granted interim bail.
That's it.
Interim period will expire on
You will come next week. This is release of seizure article, lordship.
Tied up matters, my lord, all three.
1249 of single bail for bail.
Tied up matters, my lord, all the co-accused have been released.
My lord, and of the list.
Yes.
So the first list had it.
Yes.
Revision number 46, 46, juvenile certificates, one that has been seized, my lord. From the second just
Give it. हाँ सी मु कहितली 100 मैटर आनिबा पई तो बोधे ता बियॉन्ड रे पड़ी तो 100 आरी भीतर आनिबे 119 टा आनिचंदी और नेक्स्ट वीक रे पळे आसो दियंतुनी मेमो दियंतुनी पळे आसो ऑटोमेटिक हला
Tied up bail, my lord.
गिव प्लीज गिव
CRL number 134723 value. PSA is there, my lord.
गिव इट
Well, juvenile bail, my lord.
Tied up matter.
Give it.
Interim bail has been filed for interim.
गिव इट
Lord, conviction matter. I have filed for bail and taken on next week.
गिव इट यस
Item 92 is list. The Baki double murder case. More than 10 accused have already been enlarged for your lordship. I am also similarly placed.
So I'll take up this matter. I'll go serially and likely to take up the matter. Yes.
Item 117, my lord, lordship, I am permitted to withdraw.
117. Learned counsel for the petitioner files a memo for withdrawal of the bail appeal disposed of as withdrawn. Yes.
Yesterday, my matter is similar matter of Mr. Sharma, the Banki motor case. Yesterday, Kali Koitla, a matter to take up with a Sangari.
All right. Yes.
My lord, modification. Modification of order.
Give it.
My lord, it's a vigilance case, my lord. 15/2/2023 ରୁ weekly list ରେ ଆସୁଛି madam. My lord, କିନ୍ତୁ unfortunately reach କରିପାରେ. Next week.
Aji achi.
Aji na.
Is it in the give the memo?
My lord.
Yes.
Next week.
Yes.
Supplementary list. Item number 1.
Item number 1, my lord, I for to furnish the property security. Your lord, ordinarily your lordship directed to furnish cash security.
Which order? Bail was granted to the petitioner as per order dated
9/11/21. I have annexed
9/11/2021.
I have annexed that order, Annexure 1, page 6 of the item.
So the order was passed, bail bond so and so. Then cash security is rupees 5 lakh. Then balance amount of so and so is to give undertaking, and then it has to be 10 equal monthly installment of rupees so and so. Deposit the rest amount. Okay. So what happened?
I deposited 8,50,000.
No. You must have given that initial cash security of rupees
5 lakhs.
5 lakh. Then how much you have deposited out of 32?
3,50,000.
3 lakh 50, yes.
Thereafter, by the order dated 28/3/23, as per your lordship's order, I have deposited 3 lakhs.
28/3.
In this ID. I have deposited on 13/4/23 and filed the receipts along with the additional affidavit. And thereafter, my lord, I have for the remaining amount 26,39,000, I have furnished the property security, and your lordship directed the state council to take instruction to verify the.
So that means apart from that 5 lakh, you have deposited 6.5.
Yes, my lord.
So you are supposed to deposit as per the initial order, and you must have given also an undertaking that 32,89,550. So the balance remain is
26 lakhs
26 lakh
39,550.
39,550.
For that, I have furnished the property security, my lord. Along with my additional affidavit, I have filed that, my lord.
So
So that is affidavit dated 31/7/23. I have filed the pota of the property, my lord.
No,
And,
pota of the property, it stands in name of various person.
3
So-
persons by joint family property,
Yeah.
and one of the S.K.SAHOO Behera has agreed to stand as security for his share, my lord. His share comes to half acre, total area is
No,
2
what is the cost of this land? All these things are to be assessed. So what instruction you have taken?
Yes, I have obtained instruction, my lord.
Yeah.
Last again, I pass on after the.
That property has not been mortgaged.
That property is a joint family property.
Yes,
Now.
joint.
It stands in the name of
Four
Uma Mani,
Usamani
Usamani,
Behera,
Usamani Behera and 3 sons,
3 sons.
so and so. And that is not mortgaged to anyone. That is the report. The government's made mention that the co-sharers Usamani so and so have no objection so and so. Joint property is out and false lekha ji. It is ascertained that it is an ancestral property and jointly held by 3 brothers yet to be partitioned. It is further asserted their mother is still alive and they have neither executed any agreement with so and so nor have given their consent to keep so and so as securities. What is this?
My lord, S.K.SAHOO Behera.
That cannot be. It's a joint family property. They are not agreeable to other co-sharers. So
I will furnish some, your lordship may
give
give
that
some-
copy so that he will learn in council.
Tamam,
for-
दे दीजिए क्या?
Your
Already
lord-
दे दी.
Then
your
take
lord-
instruction, yes, sir.
Your lordship may allow some time. I will arrange another.
The learning council for the Mr. J.P. Patra, learning special counsel for the state of Orissa in OPID Act matter, has furnished the written instruction received from Deputy Superintendent of Police EOW and who is also the investigating officer of the case relating to the property security, which has been mentioned in the additional affidavit filed by the petitioner dated
31/7/23.
31/7/2023. A copy of the written instruction has already been supplied to the Learned Counsel for the petitioner, who seeks some time to obtain instruction on the same. Yes. Court of this matter, give a date. Yes. So, in place of Mr. Dipali Mahapatra, the names of Mr. Nirmal Chandra Mahanti and his associates, including name of senior advocate Yashovan Das, shall be reflected. Hala? Yes.
Item 2.
PLAPL number so and so. This bail application was disposed of as per order dated 16/1/2023, in which the petitioner has been granted interim bail for a period of 3 months. This interim application has been filed for extension of interim bail order. After going through the averments taken in the IA, I am not inclined to extend the interim bail order. Accordingly, IA stands dismissed. If the petitioner has not surrendered in the court below after availing the interim bail period as per the order of this court, the Learned Trial Court shall take steps in accordance with law for the arrest of the petitioner. Copy of the order be communicated to the Learned Trial Court forthwith. Yes, by the registered judicial. Yes, next.
Item number 3.
Lordship has direct verification address, Lordship, Murshidabad, West Bengal.
Lordship may grant us some more time. We have made a correspondence.
The Learned Counsel for the state submitted that correspondence has already been made for ascertaining the correctness of the address furnished by the petitioner in the cause title of the bail application, and some more time may be granted put of this matter in such and such date. Yes.
Item 4.
Madam, Mr. Das requested for an adjournment.
Yes.
Prisoner is in custody for alleged offense under section 20B2C of the 20B2C, 25, 27, 29 of the NDPS Act, my lord.
It's also a 2021 matter.
My lord, he is
Move
in
the
custody.
trial court is a bail application of the year 2021 and the rejection order is dated 7/10/2021. If the matter is still sub judice in the court below, petitioner is at liberty to renew the prayer for bail in the said court disposed of. Yes, next.
That your lordship has, so for the connected cases, your lordship has already targeted.
Yes, yes. Next case.
Item 7.
May I please, Your Lordship? I am in custody since 2006.
Go before the court.
The bail application is of the year 2022 and the rejection order is dated 14/2/2022. The case is still sub judice. He is at liberty to renew the prayer for bail once disposed of. Yes, next.
Item 9.
May I, Lordship, please? Item 9, accused in custody 14/4/2016 and is 7 years in custody. And offense, my lord, 387, 120B, 34, 25 and 27 are marked.
So what is the stage now? The report has been received that 12 witnesses have been examined.
Yes.
Out of 44 charge sheet witnesses. So you are in custody since how many?
Since 14/4/2016.
14/4/2016.
Yes, my lord.
You have never been released on interim bail.
No, my lord.
But you have come to this court regularly. One after another bail application has been filed. And
Third round.
last time you came to this court in BLAPL number 6366 of 2022. So what order was passed in that application?
Comparison affidavit file.
I'm asking you a question. Don't try to avoid it. Let's say previous case is BLAPL number
My lord.
1902 of 2020, which has been disposed of. So, 1902 रे कौन ऑर्डर ହେଇଥିଲା? ଅଛି କପି ଅଛି ଆପଣଙ୍କ ପାଖରେ?
No, my lord.
ଏଇ ବାହାର କର। 1902 2022 2020 Arif Khan, yes, so disposed of. May 2022. Interim bail that was there. Scroll down. Scroll down. So that interim application was rejected. Prior to that, the Purva out there application was rejected. Theta. Right. So what is the how many cases are there against this
10
man?
cases. 10 cases.
So
Antecedent.
move there again. The 2022 matter is a bail application of the year 2022, and the rejection order is dated 27/6/2022. It appears that there are 10 numbers of criminal antecedents against the petitioner. After hearing the land counsel for both the parties, while not inclined to release the petitioner on bail, liberty is granted to the petitioner to renew the prayer for bail before the land and trial court. Yes, next.
Next also, my lord.
Same.
10, my lord.
Yes, next.
Item 10,
Same order. Next.
item 11,
11.
The petitioner is in custody since 2012-2019 for offenses, alleged offenses under section 420, 465, 467, 468. Let's hear the allegation is that in order to provide a medical seat, the petitioner along with others have taken money. Admittedly, my lord, the petitioner has received 17,50,000 from the complainant in his bank account. But my lords, here the case where the prime accused Dr. Raghunath Behra.
No, the
May I submit?
whether he has deposited any part of
No, my lords,
so
Dr. Raghunath Behra, although acknowledged the entire liability and on said statement, your lordship have been pleased to release him on bail, but he has not deposited. That is why your lordship has directed me to take instruction how much I can deposit. Lords, in the meantime, another co-accused, Dr. Sri Subhasis Pati, has also made a statement before the trial court, although trial has not come in, that he will also deposit some amount. What I have taken instruction, my lords, just because the petitioner has been in custody since long, he is not able to arrange money, but 1 or 2 lakhs he can deposit or if your lordship may kindly consider for
Learned counsel for the petitioner seeks some further time to obtain instruction regarding deposit of the entire amount which is alleged to have been cheated. Put up this matter after ensuing Xmas holiday. Yes, next.
my lords, may I submit?
Sorry. Yeah.
My lords,
Poor person, you have taken money and did not give him.
no, my lords, I am ready to deposit some amount.
Deposit 16-17 lakhs and come.
That's
Grant
7.
you there.
My lords, my humble submission, my lords. The
Yes,
other
next.
two.
Item 12.
Item
May I
12.
please your lordship? My lordship, I am in the BC.
Yeah.
My lordship, I am filed this case for modification of order, lordship, on dated 16th May 2023, lordship. In this case, this honorable court directed to deposit a 25% of outstanding liabilities, lordship. That is 4,80,160 total amount, lordship. Out of which 25% lordship, 1,20,040 rupees, lordship. The petition has deposited and released on bail. Then this honorable court directed to deposit the 75% of outstanding liabilities in a 3 consecutive EMIs, lordship, which is unable to pay, lordship, by the petitioner. That's why my prayer is to convert the three number of EMIs to 6 number of EMIs, lordship.
Yes, what is your that 3 he wants to 6 because of his financial condition?
My lordship, this same order also passed in the BLAPL number 13070 of 2022, lordship. In the same matter.
For the petitioner and counsel for the state. Why you have filed 2 application for modification?
No, lordship. I am filed this one, lordship, and that application was filed by the another conducting counsel, lordship.
Which this is a case where how many petitioners are there?
Lordship, 2 number of interim applications, lordship.
Mr. Counsel, there is only one petitioner, right? So the bail order has been granted and you want to modify that order, condition of the bail order. So why 2 applications have been filed, and if the counsel has been changed, one is to be not pressed? Are you following or not?
Yes, lordship. The previous conducting counsel was committed to not press.
What is your IA number? What is your IA number?
Lordship, my IA number is 1341.
All right, IA number 945 of 23. There is an application for modification of the order dated 16/5/23. The learned counsel for the petitioner doesn't want to praise this IA, which is accordingly disposed of. Then IA number 1341 of 2023. There is an application for modification of the order dated 16/5/2023. This court granted bail to the petitioner as per order dated 16/5/2023. And the operative part of the order reads as follows. Say you do let the petitioner be released on bail so and so. Say paragraph to quote kar debe pura, hala. The learned counsel for the petitioner submitted that after depositing 25% of the cash security, the petitioner has been released on bail, and he has also given undertaking before the learned trial court to deposit the balance amount in 3 equal monthly installment. However, in view of the financial stringency, it is not possible on the part of the petitioner to comply such order, and therefore the number of installments be increased, which should facilitate the petitioner to deposit the comply the order of depositing the balance amount. Land Council for the state has no serious objection. Considering the submission, the petitioner shall now the order is modified to the extent that instead of 3 equal monthly installment, the petitioner shall deposit the balance amount in 6 monthly installments. The rest part of the order remains unaltered. IA is disposed of. Yes.
The blue placed.
Item 13 earlier rejected by Honorable Justice Ekema. The earlier bail application number is 5821 of 2021, my lord. That is disposed of on 14 February 2020.
No, prior to that, I have disposed of the matter of the other co-accused person. That is how it has come. So, argue the matter. Yes.
My lord, then may I take up this matter along with item number 48.
Yes, argue the matter. I'll just now take up. Yes.
My learned senior will argue this matter.
All right, pass over next. You have received the case diary?
Yes, Your Lordship.
Yeah.
Grateful.
Item 14.
May I please use? Obedience to the order of Your Lordship, my lord, on 38/6/2023, Your Lordship is directed to furnish the affidavit regarding the local securities.
Yes.
I have filed, my lord. It has been since last 6 months, it has been lingering
Yes,
for
Mr.
verification.
It has been verified. You have received the affidavits, etc.
Yes, affidavit I have received, Your Lordship.
And what is your instruction?
Lordship may grant us some more time, Lords. We yet to receive the instruction on
When you received that?
Lords, on 12/10, Your Lordship.
12/10. So next week I will not grant further time.
Lordship.
The Learned Council for the state submitted that he has received the names, address, documents of the 2 local sureties from the Learned Council for the petitioner for its verification on 12/10/2023, and instruction has been sought for, but it is still awaited. And the matter may be taken up next week. Put up this matter next week. Yes.
Oh, please.
Item 15.
Item 15 may I prefer next week, Your Lordship.
Okay. The Learned Council for the petitioner seeks for an adjournment. Mr. Naik, Sarthak Naik, the Learned Special Public Prosecutor for the CBI is present. Put up this matter. It's next.
Item 16.
I pray, my lord, after vacation.
You have received the case diary, Mr. Tripathi. Item number 16.
Yes,
List रे लिखि दउनादी जोटारे CD अछि बेली.
Yes.
Adjournment has been sought for from the Learned Council for the petitioner. Learned Council for the state submit that he has received the case diary. Case is adjourned. List this matter 2nd week of January. Yes.
Obliged.
Item 17.
Please, my lord. Petitioner before Your Lordship, my lords, he is in custody since 14/2/2023. He was shown as an absconder, my lords, on the basis of confessional statement of co-accused, my lords, and being in custody in connection with another case, he has been produced on remand, my lords. A comprehensive affidavit has been filed, my lords, of antecedents and copies have been served.
Yes, please.
जी
फाइल लीजिए जी.
14/2 पैर
Yes, yes, that is it. Jhunnuwala set.
आ गया
You have received a copy, Mr.
Yes.
ଏଇଟା ହଉଛି ବେଲ୍ ଅର୍ଡର ଗୁଡାକ ଆମେ
I have received.
These are all bail orders, Mr.
Yes, they are all orders.
But they are under NDPS.
In all those cases, will not similar implication on the statement of co-accused that I am the supplier.
It's a man from which area?
Local millers, Banki.
Indramani set.
Indramani Sethi of Bindhanima PS Tigriya. The incident is said to have taken place on 21/4/2020, my lords.
21/4/2020. Okay. And charge sheet submitted?
Charge sheet has been submitted, my lords. Preliminary charge sheet on 17/10/2020.
Under which offenses?
Under sections, my lords, 20B2C and 29 NDPS. I have filed a copy of the charge sheet, annexure 3.
So, in the FIR, you are named as an accused.
In the FIR, it is stated, your lordship may look at page 11. Page 11, first paragraph, last part. 4 lines from the bottom. They also confess.
Page number kete कहले?
11, running page 11, plain paper FIR. First paragraph, last 4 lines.
They also confess
that Indramani Setha, son of so-and-so of Bindhanima, and Pranava Sahu alias Pintu, son of so-and-so, both PS Tigriya, are the main person dealing with ganja trading and absconded today seeing police. This is how I have been named. Now, your lordship.
And you are in custody since?
I am in custody, my lords, here in this case since 14/2/23. Your lordship also granted interim bail to the petitioner by order dated 10/11/22.
10/11?
That was prior to that. Order was passed, my lords, on
10/11/20.
10/11 was to reject extension. I have surrendered to custody and filed surrender.
See, that bail order was granted on 6/10/2020. That was on what ground it was granted?
Ailment of wife.
Ailment of the wife. Right. That was granted for about 1 month. It was granted. Then you surrendered.
Yes. And I have filed surrender certificate.
Yes, Mr.
Yes,
yes.
He has apprehended along with 402 kg of ganja.
Who has been
accused apprehension?
He is based. It's
based on
confessional. That you have also made the submission on the other day, which I have noted as per the order dated 8/12/2023. I have noted down the submission of Mr. Panda, and then I have mentioned that Learned Counsel for the state, after perusing the case diary, not disputed the submission made by Mr. Panda, Learned Counsel for the petitioner, that the only material available against the petitioner is the confessional.
Yes,
so that is that you have stated. I have noted down. Heard the Learned Counsel for the petitioner, Learned Counsel for the state. The Learned Counsel for the petitioner submitted that the occurrence in question took place on 21/4/2020 and the petitioner has been named as an accused on the basis of confessional statement of co-accused persons. And on such material, he has also been charge sheeted under section 20B 2C and 29 of the NDPS Act. And he was taken into judicial custody in connection with this case on 14/2/2023. And this court has granted interim bail to the petitioner as per order dated 6/10/2023 on account of the ailment of the wife of the petitioner for 1 month, and after availing the same, he surrendered at right time. The Land Council further submits that in view of the available material on record, the bail application may be favorably considered. Land Council for the state has not disputed that the only material available against the petitioner is the confessional statement of co-accused before police. However, he submitted that the petitioner has got criminal antecedents, and that is how the Land Council for the state was directed to file a comprehensive affidavit relating to the status of those cases. The Land Council for the petitioner has filed comprehensive affidavit annexing the bail order in those cases. Copy of the additional affidavit has been served on the Land Council for the state. Considering the submission made by the Land Council for the respective parties, the nature of accusation against the petitioner, the fact that the only material available on record against the petitioner is the confessional statement of co-accused before police, keeping in view the period of detention in judicial custody, the ratio laid down by the Honorable Supreme Court in case of Tufan Singh versus State of so-and-so, and further, the conduct of the petitioner in complying with the order of this court relating to interim bail. I am inclined to release the petitioner on bail, subject to condition that he shall not indulge in any criminal activity and appear before the London trial court on each date in the case would be posted for trial, and shall not try to tamper with the evidence. Violation of any terms and conditions shall entail cancellation of bail allowed.
Item 18.
May I please one?
The status report was called for.
I have ascertained from the local law, out of 14 witnesses, 10 witnesses have been examined, and yesterday 1 witness has been declared.
So it's a 20B2C case.
20B shows no seizure. It is alleged by the prosecution that the petitioner from the backside went to the jungle, and he was arrested after a long time.
No, what was seized in this case?
504 kg of ganja. 504 kg of ganja, and the date of occurrence is 31/7/2021.
That is 120 packets of jerry in which ganja was packed.
My lord.
So, and it was your house or what?
Yes, from the house of this petitioner.
But the Tahsildar Pidol 4 has stated that he has not ascertained about the ownership of the house.
No, ownership not necessary. The person is in who is in possession of the house, that is relevant.
But he was not present. Local man, I play 3 months. At status report.
Status report was.
Status report, it is dated 36/23.
3 months local man.
14 witnesses ru 7टा witness ହେଇଛନ୍ତି, 4टा witness decline କରାଇଛି. Our informant and 2 IOs are to be examined by the so and so.
That is Ms. Fage and Bullard.
Local man,
attendance of the informants want so. And the next date is fixed to 3/1/24.
3 months interval, local man.
You are a man from
Chitrakunda, local man, Malkani.
how many cases are there?
No antecedent.
No.
No.
And you are in custody since?
Custody, my lord, 2nd March 2022. Date of occurrence 31/7/2021.
All right, we'll keep it on 4th of, they will see that. Peruse the later dated status report dated 14/12/2023 of the London trial court, from which it appears that out of 14 charge sheet witnesses, 7 witnesses have been examined, 4 witnesses have been declined, and the case is now posted for examination of the informant and 2 investigating officers. And the date is fixed to 3/1/2024 for recording the evidence. Put up this matter on 4/1/2024. The London Counsel for the petitioner shall apprise this court as to how many witnesses were examined on that day. Copy of the order be communicated to the London trial court. This is taken on record for the day.
And I mean, 3 months local man.
All right, next date will be
Item 19.
2020. Since in the charge sheet filed, the accusation against the petitioner has not been summed up, the IO seeks some time till next week to compile the accusation against each of the petitioner of this BLAPL and other 2 connected BLAPL and give advance copy of the same to the so and so. Yes, Tapas Chandra Pradhan, SCP, June 3, Katak shall remain present. Yes. So,
may I please they handed over the copies yesterday.
You want to go through it?
Yes, my lord. Yesterday.
Yes, just now.
How can they go through and how they are largely?
He contacted me and I have solved that.
So no, the police officials are coming. So you collect the information so that their personal appearance can be dispensed with. Why they will come? Now you are ready.
Yes.
No necessity of their presence now.
No.
All right. The London counsel for the petitioner, Mr. Devasnanda, submitted that he has received and for the court, have you filed that?
Yes.
Written submission dated 13/12/2023 of filed by Mr. Tapas Chandra Pradhan, ACP, June 3, Katak, UPD, which is taken on record. The copy of the London Counsel for the petitioner, Mr. Devasnanda, submits that yesterday he was served with the copy of the written submission, and therefore he seeks some time to go through the same. In the connected matters, the London Counsel for the petitioner submitted that they have not received the copy of such written submission. London Counsel for the state supplied the same to the London Counsel in court, who also seeks time to go through the same, put up this matter on such and such date. personal appearance of Mr. Tapas Chandra Pradhan, ACP Zone 3, Cuttack, is dispensed with. So this one. Now what are the other matters?
Interim order is there, my lord.
Interim order only you Lala Amrit Sagar Roy, that will continue till next date. So you fix it in the January 1st.
21.
Okay.
My lord, item
just a minute. Interim order to continue. এটা ଗୋଟେ matter interim order ହେଇଛି, ଅନ୍ୟ ଦିଟା matter ନୁହେଁ। ତେଣୁ second week of January date ଦେଇ ଦିଅନ୍ତୁ ଆମର। Now what are the connected matters, Mr. Das?
Item number 21, 24 and 25.
ସେମିତି ତା ଦେହରେ written note ଦିଅନ୍ତୁ,
ସବୁଥିରେ ଦେଇଦେଇଛି।
respective council ମାନଙ୍କୁ ମଧ୍ୟ ଦିଅନ୍ତୁ। So 21 ରେ ଦେଖନ୍ତୁ item number 21 କୁ ଆସନ୍ତୁ। 21 ने जो BLAPL number 6511 of 2022 ता देहरे भी सेही टाइप ऑर्डर लिखिबे हैला, किंतु ये तार जो अन्य ऑफिसर थिबे सेटा देले कि आपन को
कॉपी देले ना?
Copy we have not received it.
Just now I hand
आपन को 65 जोटा आइटम नंबर 21 रो जो रिटन सबमिशन ता देले।
21 Santosh Boy is not there, my lord.
Yes, my lord. Santosh. I am present for Santosh.
Yes, my lord. My friend is there for Santosh.
On the other day it was not in the list, so we have not prepared that same.
No,
Only Santosh Boy.
Just a minute, Mr.
Other
जो फास्ट मैटर रे मिस्टर त्रिपाठी।
yes, my lord.
फास्ट मैटर रे BLAPL नंबर 9212 रे आपण देई देले नीलिमा लेंका पई देले
से तीन जन को
हां, एवं BLAPL नंबर 10618 ऑफ
देवाशीष हाजरा पे
देवाशीष हाजरा पई देई देले। तो एटा सरी गला। We are now in item number 21. आइटम नंबर 21 ने चारटा मैटर अछि।
चारटा मैटर फास्ट मैटरटा नथिला अदर डे रे।
अच्छा ठीक अछि, जो
तापर अन्य गुडा सब कर दिछु
देई देलेनी, तांको कॉपी देलेनी एवं
आकु दिया जाई छी, ताकु देई दूची।
संतोष भाई
कोर्ट को दिलु
प्रथम मैटर रे नीलिमा लेंकार अलगा देवाशीष हाजरा अलगा एडा सब रखिले।
आपण कॉपी नेबे चार दिन को
सेमती आइटम नंबर 21 ने से जो तीन जन पई देले ना नहीं। We are in item number 21 ने कहार देला मते।
My lord, I am for
please wait.
आपण पुलिस को
सेटा होची लाला अमृत सागर आदेर सेमती लिखि देबे देले एवं तादेर जो पुलिस ऑफिसर को कहैतला पर्सनल अपीयरेंस पई से प्रेजेंट नोट करिवे, प्रेजेंस नोट करिकिन तापरे पर्सनल अपीयरेंस डिस्पेंस विथ। प्रथम मैटर भी से ही इज प्रेजेंट हैला, पर्सनल अपीयरेंस इज डिस्पेंस्ड विथ। सो ए आदेर इंट्रीम ऑर्डर टा एक्सटेंड होबो। हां ओके, नाउ तापरे आउ कोन ए आपण एटा नै गेले रिटन नोट नै गेले 6511 ऑफ 23 रे
संतोष वही गोटे अछि।
संतोष वही जो अछि से नथिले
मु नंबर कहूची 6511 नेले देन आउ दीटा मैटर अछि दियंतु
के को आउ दुटा का
3188 of 23 and 9351 of 23।
हां तो सर पड़ो अपन
दीटा
आसुन आसुन कहबे हम पढि सर।
Mr. Das, you got the that instruction in that 6511?
Yes, yesterday in evening.
ठीक है ठीक। प्रत्येक केस रे अलग अलग इंस्ट्रक्शन अछि, तनु फाइल को ये रखिबे सन अलग अलग बंडल होछि तनु सन। तो 31889351 सेटार आगे कोर्ट पई दियंतो एवं तांको रेस्पेक्टिव काउंसिल को धरा देई देबे आपन। ठीक है, एटा लिखि दियंतु हला। ता धीरे जो पर्सनल अपीयरेंस जो ये थिला नोट करिवे एवं डिस्पेंस भी करबे अच्छा व्हाट अबाउट दिस फर्स्ट वन संतोष भोई
That was not there.
अच्छा
So we have not.
you
taken it.
prepare accordingly, you prepare and hand over to the land and council
Yes,
for
ma'am.
it. Right. The land and council for the state submit. This is in 3430. Right? Land council for the state submit that some more time may be granted to prepare the written note regarding the uh, materials available on record against the petitioner Santosh Goyal. Let a copy of the written submission be filed for the court to also handed over to the land and council for the petitioner put up this matter along with a you ଆଉ ତିନିଟା ଯାକ ସହିତ 6511 3188 ଆଉ 9351 ହେଲା ସେମ୍ ଅର୍ଡରରେ ମାନେ ଗୋଟେ ଡେଟ୍ ରହିବ ତମ ହେଲା ଓକେ
Interim order is there.
ହଁ
Interim order is there.
ଏଇଟା ଖଲି ପରା ଏଣ୍ଟ୍ରି
Yes,
ମର୍ଡର
yes, yes.
written note to be filed. Yes, next matter ta kon
Item 24.
Item 24, my lord.
24 24 re dita matter achi
Yes, we'll put 3.
and Mr. Das you have received the written note
Yes,
here
my yesterday evening.
same order kar diyantu written note received boli acha copy court pai file karchanti 3835 रे देखो रखिले written note अच्छा तार कनेक्ट आदर इंट्री ऑर्डर एक्सटेंड हो कोटा कहले लाला अमृत से जणे अक्यूज को इंट्री ऑर्डर है सो इंट्री ऑर्डर टू बी एक्सटेंडेड बाकी तार कनेक्टेड मैटर टा होची देवाशीष हाजरा बीएलएपीएल नंबर 11515 23 तादेर फाइल कले हां आउ कॉपी देले काउंसिल को मिस्टर त्रिपाठी देई देबे तांगो ओके सो एटा ता सहित आसीबो ओके नेक्स्ट आउ गोटे कोन मैटर रहला
Item 25, my lord.
25 25 रे केतरा मैटर टैग हेची दीटा सो एटा अपन पाई जन
Yes, my
मिस्टर
lord,
दास
sorry.
ओके
Email address.
एटारे इंट्रीम ऑर्डर एक्सटेंड हो आइटम नंबर 25 रो फर्स्ट मैटर बीएलएफएल 4016 हला इंट्रीम ऑर्डर एक्सटेंडेड एंड रिटन एटा पाइले अपन पाइले 4016 ऑफ 23 Raila?
Not received copy in this document 25.
Wait, huh? Good enough? Huh. Then now 9211 of 2023 Nilima 4016 interim order extend कर ले okay तार connected matter अच्छी 9211 of 23 आओ कोर्ट को देला आगे देखो हला आओ बाकी काउंसिल को दे देला तो
हाँ
यस ऑफिस ऑन
अरे देखुची काई छानिया होउछन तो नहीं पळेबी घर को मु तो
सेटा एटा कोन 9212 पड़ जाई छी करेक्शन कर देन तांका हाथ रे करेक्शन करन करी शॉर्ट सिग्नेचर मानो तो 9211 नंबर का चेंज कर
मतलब 34 से देनांती गोटे
पहले दे देबे
हां
तांकर जे न देले तांकर जो रूम अछि तट जाई धारणा देबे ओ यस
हम तो कल रूम रेंट संध्या बेले
यस नेक्स्ट
ओ ब्लेस
आपन को मिली गनी किन
नेक्स्ट आइटम नंबर डाकोन आ कोन रहला
item 20
यस आइटम 20 मिस्टर
May I please your lordship? In the case of 302, last occasion your lordship directed to supply a set of copy of the orders. I have already supplied the learning.
You have said that two similarly situated co-accused have been released on bail.
All the co-accused person.
So, Mr. Tripathi, Mr. Tripathi,
yes sir.
Let the police officials may leave that they have no work now. They can go and perform their duty while they are will sit here.
Yes.
Yes. Ask them to go. Yeah. Yes, item number 20.
My lord, out of 4 accused persons, already 3 accused persons released on ball, including the prime 2 accused persons. I have
Just
no
a
role
minute.
in this case. my lord.
Just a minute. PLAPL number 3254/2023. S.K.SAHOO. So, what is the date of custody?
Custody. More than 3 years. my lord.
Mr. Tripathi,
Yes, my lord.
date of custody dekhile final form de.
ब्लैंक छाड़ दीजिए
For arrest lagi
ना
No, my lord. Attended.
au blank kon chhodaichi.
फॉरवर्डेड लिखा है किंतु से जो
अच्छा
पोर्शन टा ब्लैंक
date lekhina.
किते
Have you not mentioned anywhere in your bail application since when you are in custody? Okay, in the rejection order it is mentioned it was the date is 21/9/2020. Okay, and charge sheet submitted under section.
yes that is 302
Yes.
201
Hmm.
120B
Hmm.
oblique 34 and 25 1BA oblique 27 answer.
Is it your first application or
No,
earlier rejected?
This is second application. my lord.
So what is the first one?
That's the 8666. of
866 ta no,
rejected by
click
Honorable
karan.
Chief Justice. my lord.
Okay, so dismissed as withdrawn. You withdrawn. Okay, now what is the name of the deceased? ଆପଣ ସିଏ ଆପଣ ବେଲ୍ ମୁଭ୍ କରୁଛନ୍ତି ନା ତାଙ୍କୁ ପଚାରିବେ ଡିସିଜ ନା ଆପଣ 302 ରେ ବେଲ୍ ମୁଭ୍ କରୁଛନ୍ତି ସେ ସରକାରୀ ଓକିଲଙ୍କୁ ପଚାରିବେ ଡିସିଜ ନା କଣ? What sort of preparation this? If you are not prepared, then we'll take up on some other day.
Kindly pass over, my lord.
The learned counsel for the petitioner seek some time for preparation in the case. Client ପଢିବେ ଯାକୁ ସନ୍ଧ୍ୟା ବେଳେ. Yes.
Kindly pass over.
କାଟି ଦିଅନ୍ତୁ. His case for adjournment. List this matter next week. Yes.
Item 22.
Madam, the date of occurrence is 9/2/2021, but petitioner is
Wait.
Your Lordship. The petitioner is in custody since.
Please wait.
Sorry.
Mr. Tripathi, you have received the case diary?
Just a moment.
But in this case, I have filed all deposition copies, my lord. The doubt of it.
It is taken on Monday. That is not.
As prayed for by the learned counsel for the state, list this matter on 18 December 2023. Yes.
Lordship, may I pray one thing, my lord? I have filed already a consent Viklapna. My name may be reflected by
Okay.
Sumitra Mahant.
बेसी गुड़ा लिखले आसी परिबनी ये खाली से आगे हाथ रे लिख दे मोर साइन नहीं गेल 18 तारिख पड़े आसी तापर दे फाइनल ऑर्डर आपन ना आसी यस नेक्स्ट
Item 23.
23, my lord, I am custody 12/7/2022. No incriminating material recovered from my possession.
एगुड़ा को हाथ रे तमे लिख दो
And
Well,
similar
पूरा
situated
type
accused persons were released on bail, my lord.
खाली लिख दो आज grateful is this matter on मोडिव साइन नहीं है. Yes, Mr. Panda?
Milord,
Mr. Tripathi, you have received the case diary?
P492. No, Milord. Instruction received, Milord.
What
One page.
instruction?
Instruction, Milord. And contraband article have not been recovered from my possession. And custody, Milord, 12/7/2022. But my Lord, since Milord, I have some criminal antecedent. My Lord directed to me file the comprehensive affidavit. Today I filed it, my Lord. Along with order, I have, my Lord, only 3 order, my Lord, I enclosed. I am praying, my Lord, next Wednesday I also supplied the copy, my Lord and Senior, that my Lord and Senior will verify, and by Monday I will produce another 2 order. And here, my Lord,
And the
basis
6 antecedents are there. All
That-
the 6 are NDPS.
The learned counsel for the petitioner has filed a comprehensive affidavit giving copy thereof to the learned counsel for the state. Comprehensive affidavit achi. However, he submitted that some more bail orders of the petitioner in the cases will be filed, in which he is an accused will be filed. Put up this matter, January 2020.
The day after tomorrow, similar situated accused persons are released on bail by
6 criminal antecedent, it may not be grant bail. Okay, next.
interim bail with me.
Yes, next.
Item 26.
Mr. Unmesh Chandra Jana.
Only to withdraw. It's because this matter was a judgment.
All right, disposed of as withdrawn.
Item 27.
27, my lord, the petition is custody from the 9th February 23. But
Wait, just case diary available?
Yes, my Lord.
Okay. Yes, Mr. Misra.
My lord.
What is the date of custody?
Date of 9th February 23.
9th February
23.
23.
My lord.
This is first application or earlier rejected?
Yes, my lord. The first application, well, earlier you also filed that he filed in 2015 the anticipated bail application. But that is
regular bail kotha
no,
kotha
first application, my lord.
So what are the offences under which charge sheet submitted?
457, 395.
457, 395. So FIR is unknown.
FIR is unknown.
So you have been identified in the TI period or what?
No, my lord.
My Lord, this is the case
when
of the year 2013, and he surrendered on 23.
Oh, I see.
Page 6. Well, in the meantime, the matter, the case was split up and other accused person are acquitted.
How ketera case apno na achi?
No, dita case. What are already on bail? Mane, yes, I have some. The 2 FIR. One day, 1 FIR, and day after tomorrow, another FIR. This is my 4535. And then that only because
Gotakara case of bail order.
my lord.
Are the learned counsel for the petitioner, learned counsel for the state? The learned counsel for the petitioner submitted that this is a case of the year 2013. And FIR was lodged against unknown person. Charge sheet was submitted under section 457, 395 of the Indian Penal Code. And there is no material against the petitioner except the confessional statement of co-accused. And the petitioner has got 2 criminal antecedents and he has been granted bail in such cases. And therefore the bail application may be favorably considered. He files the copy of the bail order in one case, which is taken on record. Learned counsel for the state, on the other hand, oppose the prayer for bail on the ground that the petitioner was an absconder for about 10 years. Considering the submission made by the land council for the respective parties, the nature of accusation against the petitioner, since the only material available against the petitioner is the confessional statement of who accused before police, and taking into account the period of detention in judicial custody, I am inclined to release the petitioner on bail. ଏଥିରେ ଆପଣ ଆର କେସଟା କହୁଛି କୋଉଠିକାର କୋଉ ଥାନାର କୋମନା ସେଇ ଗୋଟେ ଥାନା petitioner shall appear before the Pomna police station. ତା ଦେହରେ ହେଇଥିଲା କଣ ହେଲା once in every week. ଆଚ୍ଛା once in every week. On such date and time as is to be fixed by the London court in session till the conclusion of the trial. Yes, next allowed.
Item 28.
May please also, my lord, the petition is in custody, my lord. 31/7/2020, my lord.
CD available?
Yes, my lord.
May I pray one thing, my lord?
Yes.
My lord, the decision in question 31/7/2020, my lord. Earlier written from this bail application 11/4/74/2022. Your lordship may be heard of the merit and liberty to be trial may be expeditious, my lord. The quantity of ganja is 1057.
The learned counsel for the petitioner submitted that the petitioner is in judicial custody since keve
31/7/20.
31/7/2020 and trial arambh higilani
As per statute, no.
and therefore direction may be issued to the London trial court to expedite the trial. The London counsel for the state has no serious objection considering the submission made by the London counsel for the respective parties. The period of detention of the petitioner in judicial custody. I direct the London trial court, that is additional session judge cum special judge Parla Kemundi Gajpati, to expedite the trial and conclude the same within a period of 6 months from the date of receipt of the order. The petitioner is at liberty to renew the prayer for bail if the trial is not concluded within the said period. Copy of the order be communicated to the London trial court by the registered judicial. Yes, next.
Obligement.
Item 29.
May please, my lord. Offense is under section 302 of IPC. The petitioner.
CD available?
CD is not there, but he has 5 criminal antecedents.
CD ta anantu. The London counsel for the state submits that he has not received the case diary. However, he has received instruction that the petitioner has got 5 numbers of criminal antecedents. Put up this matter on such and such date. Case diary be obtained in the meantime. Land counsel for the petitioner shall file a comprehensive affidavit relating to the status of such cases. Number udak nahi janta tango. Yes.
Item 30.
May I please, your lordship? My lord, the mother of the petitioner was seriously ill. For that reason, one report was conferred from the concerned PS, my lord.
Asilagi?
Yes, my lord.
Kaun aila? I had gone to verify the health condition of the mother of the accused, Malati Das. During verification, it was found her health condition is not good. She is now under treatment at High Tech Swanso. There is no male member to take care of her. Received the instructions Swanso that Loko Kudiyaro,
Man of Bhubaneswar, my lord.
Offenses
302. They are
criminal
relating
antecedent, Mr.
No criminal antecedent as per my instruction.
No.
Yes, Mr.
None.
So, कौन मेरिट रे कौन material अछि?
Merit, admittedly, there was eyewitness to the occurrence. The wife and the daughter of the deceased are the eyewitness to the occurrence, and they have stated that another person was cut-hold the deceased, and the present petitioner gave stab injury to the
on the
deceased.
back and stomach of the
Madam.
Sukandar, and their evidence has been recorded.
Madam, their
Yes, ma'am.
evidence was recorded.
They have
The
supported the
informant-
prosecution case.
Madam,
Yes.
they have supported the case of prosecution. It is
The so on merit you are not getting, and so I am disposing of both the one, like on the BLAPL number so and so and IA number so and so, in view of the nature of evidence adduced by the eyewitness in the trial court against the petitioner, that he stabbed the deceased on her back and stomach with a knife, which resulted in the death of the deceased.
I think
Two, I said it's a case of double murder.
yes. No, one murder, one injured. Madam.
So who is that deceased or Nagona?
Madam, name of the deceased
Is a lady, na?
Chotulal Besra. Chotulal Besra.
Acha, Chotulal is the father of the informant.
Yes,
Father. Acha, stab the stab the deceased Chotulal kono?
Besra. Besra.
Besra, comma the father of the informant on the stomach, comma chest and other parts of the body. So also assaulted
The wife of
the mother of the informant,
Yes.
right? The
Yes.
mother of the informant on her back and stomach, and therefore I am not inclined to release the petitioner on bail on merit. However, since the learned counsel for the state has produced the written instruction received from IIC Manchester Police Station to the effect that the health condition of the mother of the petitioner is not good and she is under treatment in High Tech Medical College Hospital, Bhubaneswar, and there is no other male member in the family to take care of her. I am inclined to release the petitioner on interim bail for a period of 1 month. While on interim bail, the petitioner shall not try to come in contact with any of the prosecution witnesses or tamper with the evidence and shall not indulge in any criminal activities. Violation of any terms and conditions shall entail cancellation of bail. Yes, disposed
From
of.
the date of release, madam.
Date of release. This date of release करे देगा है ना 1 month.
Item 31.
See the case under section 302 along with other offences.
Just a minute. CD available?
CD.
In the meanwhile, 21 witnesses have been examined. I have already filed a certified copy of the 13 numbers of witnesses. Now I am filing the rest 8 numbers of witnesses deposition. And the matter may be
The learned counsel for the petitioner filed the deposition copy of some more witnesses, giving copies to the learned counsel for the state in court, who seeks some time to go through the same put of this matter after ensuing Xmas holidays. Yes.
Item 32.
May please also, man. My last occasion call for the staff test report.
Uh, 15 witnesses the total as per charge sheet. 1 witness has been examined. That is the report of the learned trial court.
My lord. That is in 2021. 1 witness is examined. That also last time we were also filed the deposition of. And he's in custody, my lord. 31/12/2019, my lord. 31/12/2019.
So how many times you have been released on interim bail?
No, my lord.
So this 3 bail application has come. Say
The other co-accused, my lord.
Acha.
One is the my lord, granted to trial may be expedited as 6 months. Also,
So this is the first bail application of the petitioner before
my
this
lord.
court.
Second bail application.
Second.
Yes, my lord.
Then first कौन आला?
First is 6 months में trial expedited कहीं करते.
Court है BLAPL number 2964.
My lord.
Have you got that?
I also supplied that copy.
Wait. Mangala Mudilito.
Yes, my lord.
Yes, Mr. 2019 so 4 ବର୍ଷ ହେଇଗଲା ଗୋଟେ ସାକ୍ଷୀ ଆପଣ କରୁଛନ୍ତି. Heard the Land and Counsel for the petitioner and counsel for the state. The Land and Counsel for the petitioner submitted that the petitioner is in judicial custody since 31/12/2019. And when he approached this court for bail for the first time in BLAPL number 2964 of 2020, as for order dated 25/1/2021, while rejecting the application for bail, Land and Trial Court was directed to expedite the trial and, if possible, to conclude the same within a period of 6 months from the date of receipt of the order. And the petitioner was given liberty to renew the prayer for bail if the trial is not concluded within the said period. Land Counsel for the petitioner submits that in the trial court only one witness has been examined out of 15 charge sheet witnesses, and therefore the petitioner may be granted interim bail for some time. Peruse the letter dated 13/12/2023 of the Land and Trial Court relating to the status of the case, wherein it is mentioned that out of 15 charge sheet witnesses, one witness has been examined. Land Counsel for the state has no serious objection to the grant of interim bail, considering the submission made by the Land and Counsel for the respective parties, since the petitioner is in judicial custody almost for 4 years by now, and only one witness has been examined in the trial court. I'm inclined to release the petitioner on interim bail for a period of 3 months. While interim on bail, he shall not indulge in any criminal activities, appear before the Land and Trial Court on each day when the case would be posted for trial. Violation of any terms and conditions shall entail cancellation of interim bail order. Yes.
So bless my lord.
Item 33.
FIR on occurrence on 7/12/2019.
CD available?
Yes, sir.
Okay.
FIR on 14.
Just
FIR on 14/12/2019 under section 363/302. Charge sheet under section 15/4/2022.
What is the date of custody?
For custody 14/12/2019.
2012.
19/12.
2012. Forwarded ହେଇଛି 20 ବାର
ନା 19 ରେ ନା ଡିସପ୍ଲେ ଯୋଉ ଚାର୍ଜ
20
12 2019
20/12/2019 ଚାର୍ଜ ସିଟ୍ କୋଉଥିରେ ହେଇଛି ଦେଖନ୍ତୁ
ଚାର୍ଜ ସିଟ୍ ହେଲା 363/302
ଟିକେ ଆପଣ ଦଉନ ହଁ
364/320
364/320
sorry 302 sorry.
So what is the name of the deceased?
Bapun alias Ratnakar Khuntia.
Bapun alias Ratnakar Khuntia.
Married.
Date of occurrence?
7/12/2019.
Is it your first application or earlier rejected?
Second, first application 4233 of 2020.
Wait, let me see that what order has been passed. It is further submitted. The occurrence in question took place also. Deceased Ratnakar Khuntia had been to Ghanteshwar Bazaar on such and such date with the petitioner in their respective motorcycle, but the deceased did not return back home. And the informant, the father of the deceased, searched for his son at different places and traced the motorcycle of his son on the next day, and he lodged a missing report. On receiving so IAC, dead body was found, abandoned house. Then the informant went to that place, identified the dead body to be that of his son. No eyewitness, circumstantial evidence. Okay. State submitted deceased was a business partner of the petitioner and relating to distribution of money collected during the course of such business, there was dispute between them. Petitioner was taken under the instance of napkin, money purse, sleeper, mobile phone of the deceased, plastic so and so were seized. Okay.
In the meantime, 3 witnesses also been examined.
Out of 34 witnesses.
And PW1 and PW2, they are the mother and brother of the deceased. They have last seen present petition with the accused person.
Okay. How ketta case achi?
No. Single case.
That instruction has not.
That mother and father, a brother, they have stated about the last scene.
Last scene. PW1 and PW2.
PW1 la mother.
PW1 brother and PW2 is the mother.
Mother. केबे लास्ट सीन इतला और डेड बॉडी केबे मिलला
से जो दिनों से मिसिंग रिपोर्ट हला से दिनों he had come to his house and asked the the deceased to go along with him, and in that night he was missing, man. And that rope also is from this
case of strangulation.
Yes, sir.
The
Especially due to strangulation.
Learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 2012-2019, and he has been charge sheeted under section 364-302 of the Indian Penal Code. When the petitioner earlier approached this court for bail in BLAPL number 4233 of 2020, as per order dated 12/1/2021, the bail application was rejected. However, liberty was granted to the petitioner to renew the prayer for bail after examination of the material witnesses in the trial court. Learned counsel further submits that it's a case based on circumstantial evidence, and the main circumstance is last seen of the deceased in the company of the petitioner, and 2 witnesses examined by the prosecution, that is mother and brother of the deceased Bapun alias Ratnakar Kuntia, have stated about the said aspect. Learned counsel submits that in view of the period of detention of the petitioner in judicial custody and slow progress of the trial, the bail application may be favorably considered. Learned counsel for the state has produced the case diary, placed the evidence of PW1 and PW2, the witnesses to the last scene. Considering the submission made by the learned counsel for the respective party, the nature of accusation, the change in the circumstances after rejection of the earlier bail application, the period of detention of the petitioner in judicial custody for about 4 years, I'm inclined to reconsider the prayer for bail and direct the petitioner to be released on bail, shall not try to tamper with the evidence, appear before the learned trial court on each date when the case would be posted for trial, violation of any terms and conditions shall entail cancellation of bail allowed.
Item 34.
My lord, active in custody 17 July 2017.
custody since 24 to 2023.
CD available?
My lord.
First bail application or earlier rejected?
It is the second bail application.
What is the first one?
First one is 3208 of
I'm sorry, but
2023.
CD is not available. The deposition copy is there. Okay. It's a 302 case.
Yes, lordships. Some of the co-accused persons has been released on bail.
No, it's all right, but he is not having the case date. Let it come next week. Let him obtain it. So put up this matter next week as prayed for by the Land Council for the state to get the case diary as well as instruction about the criminal antecedent, if any, against the petitioner. Yes. CDCA next week. Yes.
Item 36.
May I please? I'm custody since 2010-2020.
The learned counsel for the state submitted that he is expecting the case diary to be received during course of this week, and the matter may be taken up next week. Put up this matter next week. Yes.
Item 41.
41, Mr. Jena. CD available?
No, madam. CD is not available.
Koutikara.
It is a Chitrakunda, Malkangiri.
Ketara adjournment neleni? Fast.
Perceive that council has argued in another court.
No, it's all right. Case diary is not available. So even if I'm granting him time to get the case diary, put up this matter next week in order to enable the learning council for the state to get the case diary. Yes. And also the instruction about the CA. Huh?
CA has sent it now. But
Acha, CA दरकार नहीं खाली case diary नहीं जाता.
Item 42.
Yeah, please. My lordship, last time direct to obtain instruction.
What instruction?
Whether in time surrender or not, man. After having
accused, this name of the petitioner is BC alias BC Ketan. Okay. So and so. Okay. Accused was released on interim bail. Then. Okay. Then another interim bail. So, as it appears, you flouted the terms and condition of the interim bail order because you did not surrender on 18/2/2021. And non-bailable warrant of arrest was issued. And after almost 2 years and some months, the NBW could be executed and you were taken into custody. So, this is your.
in time surrender court.
2 ବର୍ଷ 4 ମାସ ପରେ ଆପଣ ଇଣ୍ଟରିମ୍ ବେଲ୍ ପିରିୟଡ ଯିବାର 2 ବର୍ଷ 4 ମାସ ପରେ ଆପଣଙ୍କୁ ଆରେଷ୍ଟ କରାଗଲା.
Before this in time surrender କରିଥିଲି ମାନେ କଷ୍ଟଡି 17/8/2017.
ଆପଣ ଲାଷ୍ଟ କଥା ମୁଁ କହୁଛି ଯେତେବେଳେ ଲାଷ୍ଟ ଟାଇମ୍ ଆପଣ ବେଲ୍ ରେ ଗଲେ you are supposed to surrender on 18/2/21.
My lord.
You did not surrender. NBW was issued on that day.
Yes, ma'am.
And your case was splitted off.
Yes, ma'am.
And you were produced by virtue on the execution of NBW on 11/6/23. So 2 ବର୍ଷ 4 ମାସ ପରେ ଆପଣ ଧରା ପଡିଲେ ତାପରେ then thereafter you are in custody.
That is also reflected in rejection order, ma'am. ଘରଟେ financial problem ଥିଲା ma'am. 2017 custody ଥିଲେ ତ ରହିଲି.
So now the case is now posted for consideration of the charge. I am giving some time to him to conclude it. Lekhandu. Peruse the status report of the London trial court from which it appears that the petitioner was granted interim bail by this court and he was supposed to surrender on 18/2/2021. But he did not surrender on that day, for which non-bailable warrant of arrest was issued against him and the case against him was splitted off. And he was produced before the London trial court on 11/6/2023 on execution of non-bailable warrant of arrest. And now the case is posted to 18/1/2024 for consideration of the charge. Since the petitioner has flouted the terms and condition of the interim bail order and did not surrender, and he could be only apprehended after 2 years and 4 months of the date on which she was supposed to surrender in the London trial court, while not inclining to release the petitioner on bail. The London trial court is directed to expedite the trial and conclude the same within a period of 6 months from the date of framing of the charge. The petitioner is at liberty to renew the prayer for bail if the trial is not concluded within the said period. Copy of this order be communicated to the London trial court by London registered judicial for compliance. Yes.
Now 43.
May I please, Lordship? Lord, this is the fifth bail application. The petitioner is in custody since 25th of
You have
October.
received the case diary?
Yes, ma'am.
25th of October
Just
2020.
first bail application?
No, my lord, this is the fifth one.
Fifth one?
My lord, in earlier last bail application, he was released on interim bail.
What is that number? What is the number?
In BLPL number 12036 of 2022.
Have you got that copy?
Yes, my lord.
Pass on, pass on.
Mr. Naik has appeared.
You also have a small.
Your name is Rinku Maharana. So you are granted interim bail for 6 weeks as per order dated 6/1/2023.
Yes, my lord, after that was extended and he has surrendered in the trial court on dated 3rd of April 2023.
So what is the stage now? The 302 case?
No, its trial is going on, and out of 42 charge sheeted witness, the informant mother and another witness Tutu Pradhan have been examined.
Are they eyewitnesses to the occurrence?
My lord, Tutu Pradhan said to be the eyewitness. Informant mother is not an eyewitness.
So what he has stated, what is the evidence copy? Have you supplied to the London State Council?
Supplying it right now.
Right now, so you will get some time to go through it. Why are you not supplying?
No, my lord, I just received it today.
All right. The London Council for the petitioner submitted that some witnesses have been examined in the trial court, including the eyewitness, and he will supply the same during course of the day to the London Council for the state. Put up this matter next week.
My lord, IA has been filed for interim bail on account of his wife's illness.
What is that IA number?
IA number 1080, my lord, of 2023.
The London Council for the...
My lord, in the earlier date, your lordship has asked for instruction regarding the IA.
Yes, have you received any instruction? Acha, in the meantime, the London Council for the state shall obtain instruction on the interim application, that is IA number 1080 of 2023, filed by the petitioner for interim bail on the ground of ailment of the wife of the petitioner. Yes, next. Matter.
Obliged.
Item 37.
The 37, Mr. Naik is here.
Lordship,
yes.
I have a small request.
Yes.
Your Lordship, if the matter can be taken by 2 p.m., I'm ready with the matter.
2 p.m. you want?
Yes, Your Lordship.
All right. Okay, I'll tell.
2 p.m.
Yes, yes.
Yes.
Yes, next.
Number 44.
Item 44, may I plead your lordship? The petition in custody since 1/8/2018, your lordship.
Yeah, just a minute. PLFBL 8627/2023. Pula alias Mrutyunjay. So earlier bail application was there.
Yes, your lordship. 5915, which was withdrawn, your lordship, on 13/10/2022, your lordship.
Pass on the order. Let us see that. That is the only application.
Yes, preferred by the present petitioner, your lordship.
Yes, no.
Other co-accused
No, we are not on other. So your date of custody is
1/8/2018, your lordship.
and charge sheet under section.
Charge sheet under 302, 34 IPC and 2527 Arms Act, your lordship. On last occasion, lordship called for a status report from the court below, your lordship.
That is already there, and it indicates that out of 37 charge sheet witnesses, 2 witnesses are reported to be dead, and 2 are untraced, and
18 have been examined.
just so far has already been examined. 19 witnesses have been examined. ଆଉ ବାକି 14ଟା witness examine ହେବେ। ତ ଆପଣ ସେ ଯୋଉ 19ଟା ସାକ୍ଷୀ ଯୋଉଗୁଡା ହେଇଗଲେଣି
18ଟା ମୁଁ ଦେଇଥିଲି already।
ଦେଇଥିଲେ।
ଆଜ୍ଞା।
ବର୍ତ୍ତମାନ ସେଇ ଯୋଉ 18ଟା ସାକ୍ଷୀର ଦେଇଥିଲେ ସେମାନଙ୍କ ଭିତରୁ କିଏ କଣ କହିଛନ୍ତି?
PW1 is the eyewitness.
Just a minute. PW1 is the eyewitness. ହଁ ସେ କଣ କହିଲା? deposition କପି ଦେଇଛନ୍ତି କୋର୍ଟ କୁ ଦେଖିଲେ?
Certified copy. Last occasion lawsuit.
Wait.
ना कोर्ट को सर्टिफाइड कॉपी दिया है।
दियंतु। को लाइन कोंतु माडो पर को लाइन टा अछि या ना होची भोला alias मृत्युंजय
Para second.
para 2
Para 2.
yes पढंतु।
I came out of my third line, my lord. I came out of my house and saw accused Bola slaying my son with a sword. Guna was assaulting Maheshwar by a bhujali and Gajanana was assaulting him by a chapboard. And Shankar was assaulting Maheshwar with an iron rod. Then the accused person, after assaulting Maheshwar, fled away from the spot.
So this man has given a sword blow. But apart from him, it is stated that the co-accused persons also assaulted him by bhujali, chapad, and
yes, madam.
That is one Shankar also assaulted by means of iron rod.
That Gajanan and Shankar, the two co-accused person is done interim bail for 3 months, madam. And this present petition has 3 criminal antecedents.
ये आगुरु जाइनी तो interim bail बोले?
ना, he was released on interim bail by the court below, your lordship.
ये गोटे order जदी ठीक ही था, ताले इतना तो withdraw कर देले। 2018 मसीहा let us see. आना होची भोला 2020 ର ଟା ଅଛି ନା ସେ ଯାଇନି ଏ ଯୋଉ interim bail ଯାଇଥିଲେ ସେମାନେ ବି assailant ଏ ଯୋଉ evidence ये लोग कोडियार
Shankar and Gajana, Puri. And he has 3 criminal antecedents, but so far others have antecedent on that part I don't know.
जो 3 CA अछि कोन को टाइप रो केस
गोटे अछि 341, 324, 320, 307, 506. Another is also 307, 386, 325, 387, 5.
Who accused you Jaithan interim bill da na kono?
Gajanan and Shankar Yellows.
Gajanan assaulted by means of a chapel. Shankar dealt iron rod. So everybody's name is there. Are the London Council for the petitioner and counsel for the state? The London Council for the petitioner submitted that the petitioner is in judicial custody since 1/8/2018 and he has been charge sheeted under section 302/34 of the IPC and section 25 and 27 of the Arms Act. And in the meantime, some of the co-accused persons have been granted interim bail by this court for a period of 3 months. And the trial has commenced. Some witnesses have been examined. Therefore, the bail application may be favorably considered. Review the status report submitted by the London Trial Court, from which it appears that 19 witnesses have been examined so far. Out of 37 charge sheet witnesses, 2 witnesses are reported to be dead and the other 2 witnesses are reported untraced. And the remaining 14 witnesses are to be examined in the trial court. London Council for the State opposed the prayer for bail and placed the evidence of PW1, who is an eyewitness to the occurrence. The London Council for the State fairly submitted that though the nature of accusation against the petitioner, so also the co-accused persons who were granted interim bail are similar in nature, but there are 3 other criminal antecedents against the petitioner. Considering the submission made by the London Council for the respective parties, nature of accusation against the petitioner, nature of evidence adduced so far in the trial court, while not inclining to release the petitioner on bail on merit, but taking into account his period of detention in judicial custody and slow progress of the trial, I am inclined to release the petitioner on interim bail for a period of 3 months. We shall not try to tamper with the evidence. Pakishura. Yes, next.
From the date of his release.
Yes, it's obvious.
Item 45.
Mr. Mulia.
It is in custody, my lord, since 28/9.
CD available?
Yes, sir.
Just a minute. 45 BLAPL 8629/2023. Is it your first application or earlier rejected?
Third application.
Third. Ago ditar kon heitla?
First application 7 months was rejected. 4C03 withdraw.
You have never been released on interim bail.
No.
Right? Okay. What is the date of custody?
Custody is 28/9/2022. 20.
2020 28 no.
28 no.
Charge sheet under section?
Section 302.
Yes.
379, 387, 294, 341, 34 of Indian penal.
Name of the deceased?
This is Ranganath.
So is it a case of eyewitnesses or circumstances?
Eyewitness. In the meantime, 6 witnesses have been examined out of 32 witness, my lord. Trusted witness. 5 are eyewitness, my lord.
What they have stated?
Report nothing against the petitioner, my lord. I annexed the evidence of.
You have annexed the deposition copy?
Yes, my lord. Annexed 2.
Annexed 2, acha. Additional PP. I know the accused, I do not remember. Okay. Yes, Mr. Tripathi.
Material witnesses are to be examined and
Okay, eyewitness
rejection order shows that manner.
Okay.
Even
He
informed
was
also.
a absconder and split of trial is going on, my lord. And the rejection order shows that so far ocular witnesses are not yet examined.
In the meantime,
And he has 7 criminal antecedents.
Acha, 7 CA.
Besides this.
Pass on, let us see. Have you filed that CA comprehensive affidavit?
No.
So, have you got all those details with?
No.
So take down and file a comprehensive affidavit. The learned counsel for the state has produced the written instruction received from so and so, which indicate that there are as many as 7 numbers of criminal antecedent against the petitioner. Learned counsel for the petitioner seeks some time to obtain instruction in respect of such CA and file a comprehensive affidavit relating to the status of the case. The learned counsel for the subpara petitioner submitted that he has instruction that out of 32 charge sheet witnesses, 6 witnesses have been examined, including 5 eyewitnesses, but they have not supported the prosecution case. Learned counsel for the state, however, submitted that from the rejection order, it appears that some material witnesses are yet to be examined. You have got the case diary? So who are those material witnesses? Okay. Let the learned counsel for the state verify the case diary and find out who are the material witnesses left out to be examined. Put up this matter. You will take up this matter. Can you file it within a week?
Yes, ma'am. Next week.
Next week. Next week, put up this matter next week as prayed for. Comprehensive affidavit to be filed, and the list of material witnesses is to be furnished by the learned counsel for the state. Yes.
Item number 46.
My lord, offense under section 20B 2C of NDPS Act, and this is the third journey of the present petitioner. In earlier occasion, Lordship plead to reject the bail application by BLAPL number 2334 of 2021 in order dated 9/8/2021, that is the annexure 6 Lordship. In that order, the Lordship observed that while inclining release the petitioner on bail, I directed the learned trial court to expedite the framing of charge and conclude the trial within a period of 6 months from the date of framing of charge, my lord. Charge has been framed, my lord, 4th July 2022. And the present petition, and lower court rejected the bail application of the present petitioner on 11/7/2023. Out of
what is the date of custody?
Date of custody, my lord, 10th February 2021.
Charge sheet under section
20B 2C. My lord, out of 3 occupants, 2 occupants including another person has already been released on bail by the my lord by the BLPL number 8726 of 2021, 7634 of 2022, 7905 of 2022. And the present petition status of the present petitioner was a driver. LS contraband quantity 34 kg to 72 grams, my lord. Out of 18 witnesses, only 5 witnesses in examined till date. So far the instruction I have obtained.
So what about the criminal antecedent, Mr. Das?
Out of the no criminal antecedent. Jhargram mane.
Jhargram mane ko state ra?
Jhargram
state ta dena diye.
West Bengal.
Hada kiye likhiyo? Have you verified the address?
No, it is not verified.
The learned counsel for the petitioner submitted that the petitioner belonged to state of West Bengal. The learned counsel for the state submitted that since the petitioner is an outsider, he may be given some time to obtain instruction whether the address furnished by the petitioner in the cause title is a correct one or not. Let the Superintendent of Police Dhenkanal District make necessary communication with the Superintendent of Police of Jharkhand District in the state of West Bengal to ascertain the correctness of the address furnished in the first title. Put up this matter. Acha, hard like Mr. Guru Prasad Behra, the Land Council, appearing through the virtual High Court of Balaso, list this matter. So we are placing it in the month of January. You get it that instruction. Okay. January address verification. Yes.
Item 47.
May I please, Your Lordship?
Past application or earlier rejected?
Earlier rejected.
That is number is?
INX, page 11, my lord.
Page 11.
Yes, my lord.
His name is Kishore Kumar Jena. So it is BLAPL number 6806 of 2022.
My lord.
Okay. Offense is 302. Eyewitness is also the injured who has supported the prosecution case during trial. While not inclining so and so, custody so and so, direct the land and trial court to expedite the trial and conclude it within 6 months. So that 6 months is over now, by now.
Last
so now
what
has come? The report is charge was framed on such and such date against 5 persons under section so and so, and 26 witnesses, including the informant, have been examined out of 38. So have you furnished the deposition copies?
Because the eyewitness injured, I annexed my bail application, where she stated that I assaulted the injured only. And I am
there may be other eyewitnesses who knows that. So why are you just giving only one statement of only one witness when 26 witnesses have already been examined?
My lord. Because I furnish the eyewitnesses, injured eyewitnesses.
सरकारी वकील देखिए कि कहबे ना आपण गोटे अधे फाइल कले केमती हो 26 टा विटनेस हेइचंती तणु आपण देबे से देखि कहबे तादिरु
May I pray one thing, my lord?
Yes.
Lordship will dispose of the interim bail. We get 3.5 years in custody for 307. That is the reason if your lordship
307.
Yes, my lord. I assaulted the injured man. Though charge sheet submitted 302, but as per my allegation is against me is concerned, page 20, lordship kindly see. He is the injured eyewitness, madam. Page 20. Last 3 lines. The accused Kishore Jena, the present.
This is na kono?
Kusum Swain. Kusuma Swain.
Mane lady ta.
My lord.
Kusuma Swain. Au e jo
injured is Mira Swain.
Mira hela injured.
My lord.
That means PW8 is an injured eyewitness. Okay.
9, my lord.
Huh?
PW9, my lord.
9.
Yes. Mira Priyadarshini Swain. Page 20. PW9, my lord.
So, kaun si kahila?
Last 3 lines, my lord. The accused Kishore Jena, the present petitioner, dealt a katuri blow on my head, causing bleeding injury, and the blood came out from my head, and I fell down on the ground. And the accused Kishore Jena dealt a katuri blow on my belly. So I assaulted the injured only, and there is no allegation that I assaulted the deceased at all, my lord.
Kusumo kiye marla? Kusumo kiye marla? Kudi chira lekhai.
Sibo.
Kahin ko line ta pahuncho.
The other accused persons, Nalini Privaswai, Kishore Jena, and Dilip Nayak, surrounded my husband. The accused Sibo assaulted the neck of my mother-in-law, Kusumo, by means of a Hansua Katuri. Just the above, my lord. As a result, she sustained cut injury on her neck, and blood came out, and she fell down on the ground. She is the
injury.
My lord.
Mr. Das, eyewitness Puchi je Sibo who accused say he neck assault korchi deceased Kusumaro. So, and so far as this petitioner is concerned, he has dealt Kotari blow on the head of this PW9 and there was injury also. Then he also assaulted on the belly. Okay. So what is the PM report? PM report of that Kusuma. How many blows he has given? Have you got the PM report with you? No. PM report is not available. What is the date of custody?
Yes, madam. 29/5/2020, madam. Got it, madam.
Charge sheet under section
341, 302, 307, 326, 294, 506/34 of the IPC, and 25 of the Arms Act, madam. And except Sibo, all are released on bail, madam, because they are assaulted, kick and fist blow.
What sort of injury this injured has sustained? This PW9.
A grievous injury, madam.
देखिए ऐसे PM report on.
That's because 326 is there. That is the reason I have submitted that.
Left shoulder 10 cm, so and so, so and so. Neck incise wound ochio. What about the CA, criminal antecedent?
No antecedent, madam.
Yeah.
No, sir. No.
No CA, madam. And this is your second or third?
Second, madam.
The first one that is 6806, right?
Madam.
All right. Heard the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 29/5/2020. And he has been charge sheeted under section 341, 302, 307, 326, 294, 506/34 of the Indian Penal Code, and section 25 of the Arms Act. When the petitioner approached this court for bail earlier in BLAPL number 6806 of 2022, in view of the statement of the injured eyewitness, this court was not inclined to grant bail to the petitioner, however, directed the London trial court to expedite the trial and conclude the same within a period of 6 months. And the petitioner was given liberty to renew the prayer for bail if the trial is not concluded within the said period. Period the status report submitted by the London trial court, which is dated 30/11/2023, from which it appears that the charge was framed on 10/1/2022 and 26 witnesses, including the informant, have been examined out of 38 charge sheet witnesses. The learned counsel for the petitioner submitted that PW9 Mira Priyadarshi Swain is an injured eyewitness to the occurrence, and though he has stated that the petitioner assaulted him by cautery. But so far as the deceased Kusuma Swai is concerned, she has attributed specific overt act against co-accused Siva, who assaulted or assaulted the deceased by means of a cautery on the neck. The learned counsel for the petitioner submitted that since no specific overt act of assault to the deceased has been attributed against the petitioner, and the petitioner is in judicial custody for more than 3.5 years, the bail application may be favorably considered. Learned counsel for the state has placed the evidence of PW9 and also on verification of the case diaries submitted that the petitioner is having no criminal antecedent. Considering the submission made by the learned counsel for the respective parties, nature of accusation against the petitioner, nature of evidence adduced so far in the trial court, period of detention of the petitioner in judicial custody, and since the petitioner is having no criminal antecedent, I am inclined to reconsider the prayer for bail and direct the petitioner to be released on bail allowed.
Item 48.
CD available, Mr. Das? Miller. CD available now?
The CD is connected matter is there. Can I pass over so wrong CD card?
So after research will take
item number 30. May I pray then? Instead of keeping it to after recess, may I suggest your lordship may keep it to the first week of reopening?
Okay. The eta sangre 13 connected. Okay. The item number 13 of 48 common order kar deve.
And I have a small prayer to make. Yes. Let my learned friend get antecedents if at all.
All right. The learned counsel for the state submitted that he has received the case diary. ये criminal antecedent instruction not किया नहीं? नहीं. अच्छा. However, he is yet to receive instruction about the criminal antecedent. Hello. Learned counsel for the and seeks for an adjournment in that respect. Put up this matter in the first week of January 2024. Etar leg de bitaso itaso, etar leg de bitaso. Hello. So this is item connected item 13 plus 48. First week January 2024. 13 plus 48. Item 13 and plus 48. Yes.
Item 49.
Yes, 49.
Please, my lords. My lords, this is a second bail application. The earlier bail application was bail application number 3612 by 2022.
You are granted interim bail.
My lords.
For a period of 4 months.
My lords.
And have you did you surrender at right time?
My lords, I surrendered at right time.
Where is this?
My lords.
That is mentioned in that rejection order.
My lords.
Okay.
That apart, my lords, in the previous bail application, while not being inclined to grant bail, my lord was pleased to grant 3 months more interim bail. That also she surrendered on time. Actually, my lords, the accused was in the family way at that point of time, and for her delivery she was granted time, and thereafter, my lords, because of the infant child, my lord was pleased to grant another 3 months of interim bail.
Petitioner is a lady.
My lords. My lords, all the other co-accused persons have been granted bail, my lords.
Now, what is the stage now?
My lords, stage of the trial?
Yes.
My lords, my instructions are that about 5 formal witnesses have been examined. 5 formal witnesses have been examined.
No, that was reflected in the rejection order itself.
My lords.
10/7/23.
My lords. My lords, my instructions are that she's again in the family way, unfortunately.
Oh, that's a different matter. All right, heard the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that the last time when the petitioner approached this court for bail in BLAPL number 3612 of 2022, as per order dated 17/1/2023, he was granted interim bail for a period of 4 months, taking into account that petitioner is a lady and she was having a baby of 4 months old. And counsel submitted that after availing the interim bail period, the petitioner surrendered at right time. And in the trial court, out of 17 charge sheet witnesses, only 5 witnesses have been examined. And therefore, the petitioner may be granted bail for some time, interim bail for some time. And counsel for the state has no serious objection for the grant of interim bail, considering the submission made by the learned counsel for the respective parties. Since the petitioner has not flouted the terms and conditions of the earlier interim bail order, keeping in view the proviso to section 437(1) CRPC, I am inclined to release the petitioner on interim bail for a period of 4 months from the date of release. Disposed of. Yes.
Pledged.
Item 50.
I'm on VC, my lord. I'm on VC. Then your lordship has been pleased to grant bail by order dated 24/11/23 and directed me to furnish the names and address of the documents of 2 local sureties who are interested to take them on bail. I have sent intimation to the father of the accused who is sick and so therefore I couldn't furnish the names and address of the witnesses, my lord. I may be permitted to submit it in another fortnight also.
Okay. As per order dated 24/11/2023, the London Trial Court has furnished the status report, from which it appears that out of 17 charge sheet witnesses, 3 witnesses have been examined.
Yes, madam.
Though the London counsel for the petitioner was asked to
एड्रेस वेरिफिकेशन में ही जाएगा.
अच्छा, एड्रेस वेरिफिकेशन no local surety for furnishing the names, address and documents of 2 local sureties who are interested to take the petitioner on bail, but since the father of the petitioner is ailing, he could not arrange the local sureties, and therefore the matter may be taken off after 2 weeks. London counsel for the state submitted. Upon address verification कर सालेन ना
No,
कोठाई?
we have already said the SP also sought for the instruction of the
The Learned and Council for the state sub paragraph लिखिए that as per the aforesaid order dated 24/11/2023, comma, instruction has already been sought for by the Superintendent of Police, Koraput, regarding address verification of the petitioner, and the instruction is awaited. In view of such submission, put up this matter. Mr. Murthy, it will be second week of the January?
Yes, my lord.
Okay.
All right.
In the second week of January, had Mr. T. N. Murthy, Learned Council, appearing through virtual High Court, Koraput at Jaipur. Yes.
Oblige, my lord.
Pass over ডাকুন দেখি তো যা আছে কেত নম্বর
Pass over item number 38.
38 PLAPL 8314/2023. Yes. What is it the first application?
Yes,
or?
yes, madam.
Huh?
Yes.
What is the date of custody?
22/6/23.
And charge sheet under section? Is it that Naxalite case?
Yes, yes, madam. Subversive conduct.
Okay. So your submission was that the only material is the confessional statement of co-accused. How many CA are there against you?
That was called for, my lord. Because
I have received no CA, lords.
that one Dengue Malik who was named in the affair, he granted bail, my lord. My lord is dealt with the Nandi set.
This man has not been named in the affair.
No, my lord.
Pradeep Pradhan, no. So, how many accused persons have been granted bail in this case?
I am with me, my lord, two. One passed by my lord and another by the Honorable Justice D. Das, my lord. I have annexed.
That is BLAPL number 9153.
Yes, my lord.
What
It was passed by my lord.
No, that is in respect of which accused?
Nandi Borset. He has also not been named.
Nandi Bodo set. Out ki jaychi?
Out jaychi say that the Dengue Malik, he has been named.
Dengue Malik.
Named in the affair accused number 4. 6.
Heard the Learned Counsel for the petitioner, Learned Counsel for the state. Considering the submission made by the Learned Counsel for the petitioner that the petitioner is in judicial custody since 22/6/2023 and he has been charge sheeted under section is you co-accused of bail order lekha ichi amaro BLAPL number 9153 of 2017 hala and further submission that the petitioner has not been named in the affair as an accused and the only material available against the petitioner is the confessional statement of co-accused before police and that co-accused persons Nandi Bodoset and Dengula Malik have been released on bail by this court And after hearing the learned counsel for the state who has produced the written instruction to the effect that the petitioner is having no criminal antecedent, I am inclined to release the petitioner on bail. But in normal conditions, allowed. Next one is
Same but separate paper and co-accused person name is also same, my lord.
no. The here also co-accused have been released on bail.
Yes, yes.
That order have been annexed.
Yes, annexed, my lord.
Okay, so same order कर देवे और बाकी
My lord's order could not be downloaded, only allowed. That is 9334.
Nandi birth set is there.
Yes, madam. That ordering person is not there. Only it is written allowed.
Okay. So out किसी 500 रो ची खाली से जो data वो रहेला.
Obliged.
So rest of the matter after lunch, madam.
Item 37, 37, Mr. Nayak, in fact, certain.
Yes.
Yes, madam. But in this case,
who is the other side?
Mr. Sarthak Nayak, CBI.
Yes.
That's all. Let's say here in this case, madam, the accused is in custody since 25th March 2015. There's almost 8 years, 8 months. Madam. And madam, during the pendency, there was an earlier application 3136 of 2018 by law. That application, in fact, my lord, was rejected and very without hearing on merit. It is simply rejected as a mistake. My lord, kind glance to that 3136 order number 24. Order number 24 of 3136, that dismissal order, the earlier bail application. 11/5/2020. My lord, that date, one interim application was pending to be heard during that COVID time, 11th of May 2020. COVID restrictions were there. So, my lord, the interim application.
How many times you have approached this court for bail during this period?
None of them. Only time, first time I made an application is 2018, my lord, which was disposed on 11/5/2020 in a wrong notion that while my lord.
The one application has been mentioned that it is BLAPL number 2686 of 2017. Then
no, my lord.
Another bail application is of 2016, 2017. Then this 23 bail application is there.
No, my only application filed by this present petitioner was 3136.
Because names are coming. Your first bail application seems to be BLAPL 5370 2016.
No, my lord, it's not by the present petitioner. The present petitioner is
सामने थुआइछि कंप्यूटर BLAPL नंबर कहूछि आपन नाही नाही कहले कोनते. Next bail application BLAPL 2686 of 2017.
No, my lord, that's not by Uttam Kundu. That is maybe wrongly recorded by the registry. It's not by me. My only application was 3136. My lord, that has come in the note also. Disposed of on 11th of May 20.
You 5370 of 2016. 2016.
That may be by that Tapas Pal or Sudeep Bandopathyay. Because five accused have been released on bail in 5 applications.
There you are granted in the first one, that is 5370 of 2016. You are granted interim bail from 20th of September 2016 to 22nd September 2016 under custody.
Those are interim. These are interim bail applications.
ମୁଁ ପଚାରୁଛି ଆପଣ ଆସିଛନ୍ତି ଆପଣ କହୁଛନ୍ତି ନାଇଁ ସେଟା ମୋର ନୁହେଁ.
No, my lord. Interim bail applications are filed along with this the pending this 313.
The number is BLAPL. That number is BLAPL 5370 of 2016. That is the first one. Next one, Barker.
One order of Honorable Justice J.P. Das is also reflected in the website, Your Lordships.
Next one is 2686 of 2017. 2686.
No, my lord.
2016.
My lord,
2017.
IN number 497 of 80 and one other IN number 351.
I've given you 2 numbers. Please go through it so that you can know. You can High Court website that of that was disposed of on 24th set of Harkon. That was also by Justice Das. The prayer has been made under so and so. The report has been called for so and so. Has been implicated with the allegation of serious economic offense, collecting thousands of crores of rupees from so and so. Earlier, granted with interim relief for performing annual Shraddha ceremony of his late father.
Yes.
But considering the nature of so that was rejected on 2687. That was rejected on 24 for back color. 24/4/2017. So these are two. Then what is the third number you said?
My lord, third number was order dated 8/5/2018.
No, number BLPL number.
BLPL number is 3136 of 2018.
3136
of 2018.
2018.
18. That's the only bail application. That was
you are repeatedly telling one only bail application. I have already showed you that there are two other bail applications filed earlier. Yes, next.
That I'll check up those things, my lord. But this application is rejected on 11/5/2025. Lordship, have kind glance to that 3136 order. Kind glance to that order number 24, dated 11/5/2020.
11/5/23.
2020, during COVID time.
That came into even in 23. That matter was there.
2020.
No, 2020, my lord. 11/5/2020. That application 3136 of 2018 was listed.
So it was rejected. Okay, then
it is rejected in the sense, my lord. The lordship, a kind glance at the first part. The application was filed for interim bail application. In the first part, second part. This is an application for interim bail filed by the petitioner, who is an accused in SP case number so and so. But my lord, while passing the final order, lordship, the main bail application was. Therefore, I filed one application for restoration. But the Honorable Court said, since the restoration application is filed after almost 1.5 years, that is rejected. So again, I was compelled to file this present application, 738.
Yes.
My lord, so far the history of the case, my lord, is concerned.
No, this is so what is the status of the case now?
Status, my lord, no charge has been framed as.
Yes, Mr. Nayak.
Lordship, it is at a pre-charge stage, your lordships.
So why a person who is in custody since 2015, you are not framing charge? So why you will not be granted bail on that ground itself? Maybe that the offenses are serious, but that does not mean that you can keep him in indefinite period without. So in this process, you will take 20-25 years.
Oh, lordship, there are already 5 charges.
I'm granting interim bail. Let him go, and you frame the charge according to your pleasure.
No, your lordship may kindly call for a report and find out the reason.
No, you are submitting. I am relying on your version that charge has not been framed. Why I will call for a report?
I'll find out the reasons why charge has not been framed, your lordships.
Maybe that whatever it may be the reason.
And
but unless the petitioner is responsible for the delay in framing the charge, why will not be granted bail?
Oh, lordship, I have twofold submissions.
Yes.
Number one, your lordships, as far as the investigation qua this accused is concerned, that is not complete, your lordships. Even if your lordship CBI took up the investigation,
you may take 100 years for completing your investigation. So let him go on bail. Then you complete your for 8 years he is in custody. 8
years, 8 months.
8 years, 8 months.
Your lordships, twice he was out when he was out on interim bail, your lordships.
Only for 7 days. 7 days. Only for 7 days. Only for 7 days. That is in 2018.
All right, I'm taking up this matter next week. I'm calling for the status of the case. The Mr. Manas Mahapatra, learned senior advocate appearing for the petitioner, submitted that the petitioner was taken into judicial custody since 25/3/2015, and in the meantime he was granted interim bail for few days, and he has received instruction that till date no charge has been framed. Mr. Sarthak Nayak, learned special public prosecutor appearing for the CBI, doesn't dispute such submission, but submitted that the investigation, so far as the petitioner is concerned, has not yet been completed. Since in the meantime, 8 years and 8 months have already passed since date of taking of judicial custody, and it is stated that charge has not yet been framed. Let a status report be called for from the Land and Trial Court.
One more submission, lordships.
the put up this matter on Wednesday again. That would be on 20th of December 2023. Registered judicial shall send email to the concerned court for obtaining the status report, which will be submitted by 19th of December 2023. Yes.
Your Lordship, will take only 30 more seconds.
Okay. Make your submission on the next date. Yes.
Okay.
Yes, next.
Item number 51.
51, I may be permitted to place this matter on behalf of Mr. Swaraj Patel, my lord.
You have received the case diary? Is it the first bail application?
Yes, my lord.
Wait.
My lord.
So what is the date of custody?
Date of custody is 26 2023, my lord.
20.
20.
2023.
Yes, my lord.
What are the offences under which charge sheet submitted?
Charge sheet submitted under section 387, 506, 507, 420 and 109 of Indian Penal Code. Reduced section 27 of Arms Act, my lord. The charge sheet submitted on 31st 5 2023, my lord. Here the FIR was filed in the year 2017 against unknown person by one Himanshu Pradhan, alleging that he has received a telephone call. His employee of a temporary camp have received telephone call from unknown persons, and after some time the person who was giving call, he himself identified as as Arjun Rana. Thereafter demanded 8% of the work amount. Otherwise, the work should not be commenced. This is the allegation for which the FIR was registered. In the meantime, five of the accused persons, they have been implicated. This is the third charge sheet has been submitted by the prosecution. So far as
what is the material against the petitioner?
Against the present petitioner, except the confessional of the co-accused statement, there is no other material. And
how many cases you have got?
No, my lord.
Yes, Mr.
In case of 2017, he was absconded on the basis of the individual he was arrested. And so for the antecedent concern, I have not received. Sorry, he is involved in another case, my lord. That is 65 cases, 65 under section 340 and 320
No, in this case,
that is the allegation. He has some Airtel SIMs. The activated from Airtel SIMs, my lord. And that through that SIMs.
The threat was given. Or the learned counsel for the petitioner, learned counsel for the state. Considering the submission made by the learned counsel for the petitioner, that the petitioner is in judicial custody since 26/2023, been charge sheeted under section 387, 506, 507, 420, 109 IPC and section 27 of the Arms Act. And the only material available against the petitioner is the confessional statement of co-accused before police. And after hearing the learned counsel for the state, who submitted that the petitioner has got one criminal antecedent of magistrate tribal offences, I am inclined to release the petitioner on bail allowed.
Number 52.
May I please, Your Lordship. The petitioner was charge sheeted under section 450, 307, 302.
Received case diary.
No, my
So, which police station it is?
Bijapur, Bargarh district.
First time it is.
This
Earlier bail application was rejected or
earlier thrice rejected, Your Lordship. This is the fourth application.
All right. Status of the case Magantu. How case diary produce kariya pai. Yes, next.
Item 53.
May I please, my lords? Lords, the petitioner
CD
is
available?
53, my lord. My lord.
Okay. Dita matter is
My lord.
9049 2023. Sushant Bhue. So, what is the date of custody of Sushanta?
Lords, 15/1/2023.
15/1/2023. Connected matter hela BLAPL 9146/2023. Horrible Bhue. तार कस्टडी केबे
14/1/23, my lord.
14/1/2023. चार्जशीट कोथरे इछि
On section 302, 307, and 34 of the Indian Penal Code, my lords, on 4/5/2023.
So what is the name of the deceased?
Subharchan Bhue.
Huh?
Subharchan Bhue.
Subharchan.
Aye.
And who is the injured?
Lords,
307 is there.
my lords, when charge sheeted, there is no other injured person, my lords.
So then why 307, 302? Mr. Das? ଜଣକୁ ଇଏ ତ ହେଇଛି ସେ ତ ମଲା 307 ପୁଣି କଣ 323 ରୁ ଲଗେଇ ଦେଇ ଚାଲିଗଲେନି 324 25 26 ସବୁ ଲଗେଇ ଦେଇ ଚାଲିଯିବ 7 ଶେଷକୁ 2 ରେ ସରିବେ.
In the meantime, my lords was pleased to release similarly situated accused persons, two accused. One is namely Gopal Thapa, Bhait BLAPL number 6322 of 2023, and another is Biswanath Sahu, Bhait BLAPL number 2998 of 23.
Wait. FIR name doesn't find place. Eyewitnesses are not implicated. So that is the reason why they were granted bail.
My lords.
So here, who is the eyewitness?
The eyewitness, one Purno Behera and one Gunanidhi Bhue, my lords. Well,
देखले गोटे स्टेटमेंट काढिले eyewitness रो पूर्ण बेहरा. Okay. कौन से कहूची आप ये माड़ विषय रे डिसीज्ड और ता विषय relevant part टा पढुन.
ହେଲେ ସେମାନେ ମତେ ଆଉ ମୋର ପୁଅକେ ଧରିକିରି ଆମେ ଜୀବନ ମାରିଦେବା ଉଦ୍ଦେଶ୍ୟରେ ସୁରୁ ହୁଏ ମୋର ଛାତିରେ ନାକରେ ବୁସିଦେଲା.
କିଏ
ସୁରୁ ହୁଏ.
କିଏ?
The principal assailant, Keshav alias Suru Bhue.
तान ये सुशांत नुहे तो सी
No.
सुरू भुए तान और आउ गोटे ना कोन
Keshav. आज्ञा.
अच्छा हां कोन कला पढन
ମୋ ଛାତିରେ ନାକରେ ବୁସିଦେଲା.
कोन कोथरे
Screwdriver.
अच्छा
ମତେ ପେଚକସରେ ବୁସି ଥିବାରୁ ମୋର ଛାତି ନାକେ ଦାନ୍ତେ ବହୁତ ରକ୍ତ ବାହାରିଲା. ମୋର ପୁଅ ଗୁଣନଦୀ ତା ଛାତିରେ କାନରେ ଆଉ ପିଠିରେ ସେମାନେ ବୁସି ପକାଇଲେ. ତାର ବି ବହୁତ ରକ୍ତ ବାହାରିଲା.
କିଏ ଆଉ କିଏ ମାରଲେ
ଗୁଣନଦୀକୁ ମାରିଲେ ମାନେ ତା ପୁଅ ଡିସିଜ ମାର.
हां डिसीज ना पराउची सुबर्छन भुए कहले
ପୁଅ ଗୁଣନଦୀ ର ଛାତିରେ କାନରେ ଆଉ ପିଠିରେ ବି ବୁସି ଦେଲେ. ସେ ଆନନ୍ଦ ଇଞ୍ଜୁର୍ଡ. ତାପରେ ଆମେ କଷ୍ଟମଷ୍ଟେ ଛଡେଇ କରି ଆମ ଘର ଆଡକୁ ଗଲୁ. ହେଲେ ସେମାନେ ମୋର ପୁତୁରା ଦେହ ଜଣେ ଜଣେ କରି ପେଚକସଟି ବୁଝିଥିଲେ. ସେମାନେ ମୋର ପୁତୁରାର ସୁବର୍ଣ୍ଣ ହୁଏ ଇଏ ମରିଗଲା ବୋଲି ଭାବି ସେମାନେ ତାକୁ ଗୋଟେ ଧଳାକାରରେ ଗୋଟେ ବାଇକ ରେ ବସିକରି ପଳାଇ ଗଲେ. ତାପରେ ଆମେ ପାସକେ ଯାଇ ଦେଖିଲୁ ଯେ ସୁବର୍ଣ୍ଣ ଅଛି ତାର ଘର सामने पड़ता या पुणी आंबुलांस मेडिकल नहीं गले another matter witness complainant devotion of Bhui यह प्राय राति प्राय 11टा समय केशव भुए जने सांग कार ड्राइवर समुदाय 4 जन गोटे कार रे आसिले और सहित त्रिलोचन भुए और सुशांत भुए
पिटिशनर
मिसी मोर भाई को जीवन रू मारी देबा उद्देश्य रखी मारपीट कले हरिबोल भुई और अन्य माने मोर भाई को धरी तले पकाई देले केशव भुए एक पेचकस भली धारुआ अस्त्र मोर भाई को मुंडरे बेकरे अन्य जगह बारंबार भूसीदेला जहाँ फल मोर भाई रक्ताक्त हो तले पड़गला
सो मेन एलिगेशन आसुची केशव नारे स्पेसिफिक आउ कौन सीए कौन अच्छी क्रिमिनल एंटीसीडेंट
No antecedent, my lords, as per my instruction.
सुशांत भुई रे एंटीसेंट किस नहीं
बाकी हरि बोलो heard the learned counsel for the petitioner dita common order कर दे learned counsel for the petitioner submitted that the petitioner Sushant Bhue is in judicial custody since 15/1/2023 and the petitioner Haribolo Bhue is in judicial custody since 14/1/23 and they have been charge sheeted under section 302 307 by 34 of the Indian Penal Code and the main allegation is against Suru Bhue alias Keshav, who stated to have assaulted the deceased Surbachan Bhue by means of a screwdriver and two accused persons, namely Gopal Thappa and Vishwanath Sahu, have already been released on bail by this court in BLAPL number 6322 of 2023 and BLAPL number 2998 of 2023 and therefore the bail application may be favorably considered. Stop. Learned counsel for the state place the statement of the injured Purno Behera, so also the informant Devarchan Abhue. Considering the submission made by the learned counsel for the respective parties' nature of accusation against the petitioners, and since the main allegation of assault is against Suru Bhue alias Kesav, for the taking into account the period of detention of the petitioner in judicial custody, I am inclined to release the petitioners on bail allowed. Detail. Very good line लिखी since say both the cases arise out of same case, that is so and so with the consent of parties they are heard together and disposed of common order. In view of the order passed in so and so this case is disposed of. Okay.
Item number 54.
May I please, Your Lordship?
What's case diary?
Petitioner is in
Just
both the item notes.
54 and 101 arises out of same case.
Same case.
All right. BLAPL 9111 2023 and Sheikh Mohi Fuj, single
Yes.
petitioner.
Single petitioner, yes.
Mohi Fuj alias Naveen. And then 101. That is BLAPL 13242 2023 Abdul Masroor Khan. Okay. What is the period of detention?
मतलब the 19/6/2022.
Is it the first application
Yes,
or
मतलब first application.
19/6/2022?
22 मतलब.
दी जन जाकर ना कहा
दी जन जाकर मतलब.
Okay. What are the offences under which charge sheet submitted?
मतलब the 364, 302, 201, 34 IPC.
What is the name of the deceased?
Plus the Ahulla Khan, Atwala Khan.
Huh?
Atwala Khan, ATAUAA,
ATA?
ATAULLA Khan.
Date of occurrence?
Date of occurrence, my lord, 18/6/2022. Granted. Yes. Page 31, my lord, running page 31. Co-accused, similar to
So there is no eyewitness to the case is based on materials in record. Deceased Ataullah Khan is the husband of the informed having illicit relationship with a lady of the village, and according to the prosecution, the petitioner called the deceased on so and took him to the house of that lady with whom he had illicit relations in his motorcycle. And on the next day, so the dead body of the deceased was found in a stone quarry. Land Council submitted that the imbue Land Council state doesn't dispute that the case is based on circumstances. Replace the statement of one Farooq Khan, stated last seen the petitioner in the company of Ataullah Khan, further stated that the petitioner is taking the deceased to the house of the lady with whom he had illicit relationship. Petitioner has got one criminal antecedent. So this last scene to thila ta sangere je bail jaiji.
This same miller last in theory circumstance evidence.
No, last scene to khali tari sangere jaitila bel.
It is circumstances evidence miller. The Farooq Khan, so far the statement of Farooq Khan. If you permit me.
What role has been played by this petitioner, two petitioners?
मो नाम फारूक खान आज 8/10/2022 रिखरे बयान देउछि कि आज 3 वर्ष तळे पंचायत पार्क पाखरे गोटे फास्ट फूड दुकान अछि गत 16/6/2022 रिख संध्या बेले रिंकू अतवाल खान और पिला दुई जण रिंकूर ग्लैमर मोटरसाइकेल ले आसी मो दुकान रे पहुंचले एवं अंडा चॉप खाइले एवं सरफेस नेले मु रिंकू को पचारिवा से कहला दुहे पाईकती गिरिया रो अलीमा बेगम घर को जाउछंती जेहेतु अलीमा बेगम को सहित अतवाला खान और पिलार अनैतिक संपर्क थिला मु ता कथारे विश्वास करथिली किंतु मझिरे मझिरे आम पंचायत ऑफिस रे अलीमा बेगम धमक देइथिला कि अतवाल खान जदि तार न हेबो काहार हेबाकू देबिनी एवं एहे भितरे मरिबो बोली धमक देइथिला परे 17 तारिख दिन सुनिबा को पाइली जे आम गाँर रिंकू अलीमा बेगम और
से जो आस्थिला से जो अंडा चॉप खाइला किए थिले
Sheikh Sarif below. Here the Sheikh Sarif is not.
गत 16/6/2022 तारिख संध्या बेले मु दुकान थिबा समय रे आम गाँर रिंकू तार ग्लैमर मोटरसाइकल रे
बेल दिया
आगे अतुल खान डिसीज पिला को बसाई नहीं पाइक करिया आड़कू जाइतला परे 17/6/2022 तारिख दिन शुणिया को पाइली जे आम गाँर रिंकू अलीमा बेगम रो ओरफ डली आलिमा बेगम रो पुत्रा अब्दुल मंसूर खान ओरफ भुतुलु एंड तार पुत्र शेख मजीबुत अलियास नवीन योजना मुतक अतुल खान और पिला को तार घर
there is no last scene is with that Rinku
only circumstantial evidence.
Are the land and counsel for the petitioners the data ko gote common order karibe item number 54 or 101 hala so the land and counsel for the petitioner submitted that both the petitioners are in judicial custody since 19/6/2022 and they have been charge sheeted under section 364, 302, 201 by 34 of the Indian Penal Code. Case is based on circumstantial evidence and the Larsen theory is applicable, is against only Sheikh co-accused example. Sheikh Masur, Mashur Rahman alias Rinku, who has already been Larsen of the deceased Ataullah Khan, Ataulla Khan, was with the co-accused so and so, Sheikh Masur Rahman, who has already been released on bail by this court in BLAPL number 11455 of 2022, 11,455 of 2022 as per order dated 25/7/2023, and there is no clinching material on record against the petitioner relating to their involvement, and therefore the bail application may be favorably considered. Land Counsel for the state produced the case diary, placed the statement of Farooq Khan and Sheikh Sharif. Considering the submission made by the Land Counsel for the respective parties, nature of accusation against the petitioner, absence of any direct evidence, nature of circumstantial evidence on record, release of the co-accused on bail, and further taking into account period of detention in judicial custody, I am inclined to release the petitioners on bail. Petitioners kariye. Line both the matters arises out of one case, heard analogously and disposed of by the common order. Okay. Yeah. Grateful.
Item 55.
101 file ta de do.
May I please, Your Lordship?
Just a minute. Case diary achi?
No, my lord.
Get the case diary. Koop thana ro asibo.
My lord, earlier last occasion, Your Lordship sought for the status
No,
report.
seta ta asjaychi case diary ta. Okay, status report indicate kuruchi. Charge has been framed and 2 witnesses have been examined. You are in custody since when?
Since, my lord, 9/1/2022.
Okay.
And earlier, my lord, twice the petitioner was on interim bail, and he has not also violated the conditions and surrender in time, my lord.
Why you are granted interim bail?
My lord, on health ground for operation of the wife, my lord.
In this application or earlier?
Earlier application, my lord.
What is that number?
That is 4468 of 2022. Your Lordship's order is there 13/2/2023, annexed to page 9. Your Lordship has targeted the matter for
right,
6.
that is there.
My
Then
lord.
no, interim bail order sei thre diya ithla.
Interim bail, my lord, thila. First was 22/9/2022.
Sei bail application dare.
Agya 4468 re.
4468 record kain. Eda.
22/9/2022. Thereafter, my lord, 19/12/2022.
You surrendered at right time.
Right time, my lord.
All right. So let you bring that case diary. The Land Counsel for the state seeks some time to produce the case diary. Since the petitioner is stated to have been released on interim bail twice, the Land Counsel for the state shall also obtain instruction as to whether during interim bail period there is any allegation against the petitioner to have misutilized his liberty or not. Put up this matter, give there. Yes, next. I have paid you the status report submitted by the Land Trial Court at flag B at election. Yes.
56.
May I please, Your Honor, sir?
56.
My lord, on behalf of Mr. B. Mansingh, my lord, kindly pass over the matter, my lord.
Interim bail कौन पाई? Interim bail instruction नहीं चंदी कौन पाई फाइल कर चंदी interim bail?
59.
Mother's ailment कौन लिख चंदी? किसी document भी की देना? खाली लिख चंदी ground of mother's ailment which may be kindly allowed.
Interim application भी देना
दिया
My lord, kindly pass over the matter, my lord.
कॉपी टा देवे ना पासवर्ड कौन कले?
से कोर्ट ଅଛନ୍ତି। ଆଚ୍ଛା।
You have not stated anything in your interim application.
Lordship,
What is the disease? What and no medical document?
medical certificate.
मते बड़ी लगन मु जीवा तंग ना को.
I have given the copy.
Is not copy has not been given. Give the copy as well as the medical document.
Medical
IN
document
number,
I have.
IN number 1101 of 23 is an application for interim bail on the ground of ailment of the mother of the petitioner. Let a copy of the interim application with the medical document be handed over to the Land and Council for the state in court. Will obtain instruction on the same of this matter on such and such date. Yes, next. Copy दियंतु. आइए copy दियंतु.
Item 57.
57 में केस डायरी अच्छी 57 BLFPL अच्छा
offense under section
wait
396.
BLFPL 9242/2023 Rajendra Singh alias
56 तक next week रहला ना
Chavra. नहीं it is after right 2014 है ये 24 हाँ ये custody
my lord more than 6 years my lord since 30th January 2017 he is in judicial custody.
How many times you have approached
That
this
is a
court?
third time my lord.
What orders were passed earlier? You approached this court in 2017 also. That is BLFPL number 6683 of 2017.
My lord.
Then Chavra. Another is 1308 of 2019. Have you got those copy of the bail orders?
Yes, my lord.
So the first one is that offense has been noted down 396 case identified in the TI period, bail rejected. Second one
was withdrawn, my lord.
Withdrawn. Then what is the trial position now?
My lord, out of 38 charges witnesses, my lord, 12 witnesses have been examined, my lord, including the informant and the.
Have you supplied deposition copies to the
Yes,
State
my lord, I have
Council?
already supplied.
My lord. Mr. So
Last
what?
witness again on July, my lord.
It's all right. So those identifying witness have been examined.
Yes, my
because
lord.
it's a 396 case. What they have stated, whether they identified you in court or not. They have identified
Yes,
you
my lord,
in
they
TI
have
period.
identified, but my lord, the TI period, the procedure of the TI period, they have.
Argument करिवे trial court रे एठी वर्तमान procedure कौन हो? बड़ी bail ले procedure लिखिवे और से कौन करिवे? Yes.
More than 6 years, my lord, entry.
6 year 396. So how many cases you have got?
No criminal.
And who is that witness who has identified you? PW?
PW, my lord.
That
PW 8, my lord.
8 is the one of the inmates of that house where Dokaiti with murder took place or what?
Yes, my lord. He was present at the spot, my lord.
What is the name of that PW8?
Maheshwar Pradhan, my lord.
Maheshwar?
Pradhan.
Pradhan. ମହେଶ୍ୱର ପ୍ରଧାନ ବର୍ତ୍ତମାନ ଗୁରୁତର ଅବସ୍ଥାରେ IGH ରେ ଚିକିତ୍ସା ହେଉଅଛି। ମହେଶ୍ୱର ପ୍ରଧାନ ପଚାରିବାରେ ସେ କହିଲା ଯେ 6 ଜଣ ପିଲା 800 ଟଙ୍କା ଭଡାରେ ବୀରମୂତ୍ରପୁର ଯିବାକୁ କହିବାରୁ ସେମାନେ ତାଙ୍କୁ ନେଇକି ବୀରମୂତ୍ରପୁର ଯାଇଥିଲେ। ହେଲେ स्वांस रास्तारे वाहन गाड़ी अटकाइले भुजाली रे आक्रमण कले ओके Master Pradhan identify kala upon my lord in court also. Yes. What is the deposition copy? State Council को देई चंदी आया लेके आए ले
In cross examination also, my lord, in para 8 and 9, so yes. In 8 and cross examination, my lord. In para 8 and 9, he has category stated that I have identified the accused person and 4 accused person and the second time 2.
The second instance.
At the first instance, I identified 4 accused persons, and thereafter, at the second instance, I identified 2 accused persons.
Right.
Again, my lord, in para 9, second line, third line, on the date of TI period, I identified 4 accused persons and returned back. Constantly, he has identified.
And next, I do not remember if I have told.
That's something different.
Reason for identification of accused person. I have not told the magistrate about the role played by the accused persons during the occurrence.
And also in para 10, my lord, it is not a fact that I have seen the accused person at police station. And also I have seen their photographs while publishing the newspaper to the TI period. It is not fact that I have said all the is consistent, my lord.
Point 6, my lord. The last person's matter. Prior to examination by the police, I had not disclosed about the occurrence to others. I have described the features of the body construction of the said 6 persons before the police. I do not remember when I was discharged from hospital.
He is an injured eyewitness who has not only identified you in PI period but also in court, and it's a case under section 396. So you are right that you are in custody since it is almost 6 years, 7 years, no, 6 years, 11 months, 10 months have passed. So any criminal antecedent against the petition?
No.
Heard the London Council for the petition. This date is making a correct submission. 31/2017 is considering the submission made by the Land Council for the petitioner, that the petitioner is in judicial custody since 31/2017, and he has been charge sheeted under section. What are the offenses?
396, 397, 324.
396, 397,
324,
324,
and 25 and 27
and
also
25 and 27 of Arms Act. And in the meantime, trial has commenced. Out of 38 charge sheet witnesses, 12 witnesses have already been examined. and there is no criminal antecedent against the petitioner. And after hearing the learned counsel for the state, who placed the statement of PW8 Maheshwar Pradhan and submitted that the petitioner was not only identified in the TI parrot but also in court by PW8, and further taking into account the nature of evidence adduced and the inordinate delay in disposal of the trial, I am inclined to release the petitioner on bail allowed. Yes.
Item 58.
May I please judge?
PD available? Mr. Das? ଅଛି ତ?
ନା ସିଡି ଆଭଲ
କୋଉଠି ଆସିବ?
ଏଟା ଫିରିଙ୍ଗିଆ
Status report ଟା ପଳେଇ ଆସିଛି।
Yes,
Once
17.
NBW was issued,
NDPS ଟା
one witness has been examined, discharged. Two witnesses has been examined, so total କେତେଟା ହେଲେ?
My lord, in this case, my lord, 3 co-accused persons have already been acquitted. I have annexed 3, my lord.
କେସ୍ ହଉଛି 2017
ଆଜ୍ଞା
17.
ଆପଣ କେବେ ଧରା ପଡିଲେ?
My lord,
ଆପଣ this span is ଟଙ୍କଧର
he was released on
you are released on interim
bail,
bail,
my lord, on
then
11/7/2018, my lord.
absconded and case against you was splitted off
Yes, my lord.
on 9/1/2020 and trial against the co-accused persons proceeded, and then 2/6/2023 ରେ ଆପଣଙ୍କୁ ଧରା ପଡିଲେ, ଅର୍ଥାତ୍ 2018 ମସିହାରୁ ଆପଣ ଇଣ୍ଟରିମ୍ ବେଲ୍ ପାଇ ସରେଣ୍ଡର କଲେନି। 16/8/2018 ରେ ସରେଣ୍ଡର କରିବାର ଥିଲା, ବାକି ନ କରିକିନି ଆପଣ NBW ଏକ୍ଜିକ୍ୟୁଟ ହେଲା ପରେ ପ୍ରାୟ 5 ବର୍ଷ ପରେ ଆସି କଷ୍ଟଡି ଗଲେ, ତେଣୁ ବର୍ତ୍ତମାନ ବେଲ୍ ପ୍ରଶ୍ନ ନାହିଁ, ଟ୍ରାଏଲ ଫେସ୍ କରନ୍ତୁ, ସରିଯିବ। ଦେଖନ୍ତୁ, had the learned counsel for the petitioner, learned counsel for the state review the status report submitted by the learned session judge Kandhamal Fulbani dated 2/12/2023, from which it appears that the petitioner was released on interim bail as per the order of this court on 18/7/2018, and though you are supposed to surrender on 16/8/2018, but he did not surrender, for which non-bailable warrant of arrest was issued against him, and the case against the petitioner was splitted off, and ultimately on 2/6/2023 the NBW was executed. Considering the submission made by the learned counsel for the parties, and since the petitioner has flouted the terms and conditions of the interim bail order, I am not inclined to release the petitioner on bail. However, the learned trial court shall do well to expedite the trial and conclude the same within a period of 6 months from the date
My
of
lord, in this case,
receipt of the order. The petitioner is at liberty to renew the prayer for bail if the trial is not concluded within the said period.
3 months, my lord, co-accused acquitted, my lord. 3 months time.
Yes, co-accused acquittal ଆପଣଙ୍କୁ acquittal କରିଦେବ ନା କଣ? Trial ଫେସ୍ କଲେନି, ଟ୍ରାଏଲ ତାଙ୍କ ସାଙ୍ଗରେ 5 ବର୍ଷ ଧରି ଫେରାର କାହିଁ ହେଇଯାଉଥିଲେ? Yes, next.
Item 59.
मतलब तो petition is custody since
CD available?
4/11/2020. मतलब co-accused person bail order is annexed 3 series में.
ଆଉ CD ଆସୁ the learned
3 ବର୍ଷ
counsel
ହେଲା
for the state 3 ବର୍ଷ ହେଲାଣି CD ଆସିନି?
ନାଇଁ 3 ବର୍ଷ ହେଲା custody.
ଆସୁ କେସ୍ ଦେଖ, the learned counsel for the state seeks some further time to obtain the case diary as well as instruction about the criminal antecedent. Please this matter, give a date. Yes, next.
Item 60.
May I please, Your Honor? Already I am on BC measure.
8/11/2020. It is the fourth round journey, my lord.
CD asile.
Lord, the instruction we have received is that case diary is there in a connected matter, Your Lordship.
Now next week ne
My lords, next week.
Next week it is stated by Mr. Misra that the case diary is available in the connected case. The matter may be taken up next week. All right. Obliged.
Item number 62.
May I please, my lords? The petition and custody, my lords. Since my lord.
CD achi?
No, my lord, CD we are yet to
Who does you?
Lords, Patapur PS.
Ganjam.
Ganjam, Your Lordship.
All right. Time sought for the CD and C. Okay. Next.
24/11 में तो direction दिया है
That will be the order number 1. This would be the order number 2. Yes.
Lordship, calling it next week, my lord.
Yes, yes.
Pardon, my lord. Item 61, my lord, the petitioner's health condition ailment is very bad.
Code कितना number?
61 ta.
61 ने खाली add कर दिया तो the Land and Council for the state shall also obtain instruction about the health condition of the petitioner to the concerned jail superintendent. को jail कर रही कौन? Yes.
Kumarpuram. Puri jail में. Puri.
Item
63.
63.
My lord, in this case, the allegation made against the petitioner, 3
available?
Yes, Your Lordship.
This is the second journey of the.
Wait. 64 BLAPL 9430-2023. Nepal NEPL Mundari. So what is the date of custody?
Custody since my lord 21/7/2019.
ଆଗରୁ ଆସିଥିଲେ?
Yes, my lord. This is second journey.
Second journey. କଣ ହେଲା ସେ order କୋଉଥିରେ?
That is the liberty was given to the petitioner after examination of material.
And been charge sheeted 302201. Occurrence took place and so and so. No eyewitness to the occurrence and so and so. Sugamundu with the father-in-law of the petition law, the suspected that the petitioner has committed murder of his wife Sambari Munde. Others, in view of the confessional statement of the petitioner before police and the manner in which the occurrence was taken, State, on the other hand, submitted that the petitioner made extrajudicial confession before Jaddu Mani Mundari and Samo Mundari, and on the basis of the statement recorded under section 27, one spade was recovered and the dead body of the deceased was also recovered from the place of burial by digging earth. Extrajudicial, the petition was categorically stated to praise the neck of the deceased, killed her and then buried her in the dead body. So this was rejected.
Yes.
Then you are granted liberty to renew the prayer for bail after examination of the material witnesses.
Yes, my lord. In the meantime,
yes,
7 witnesses have been examined. And that Sama Mundari, who before
that statement you have given to the Mr. Mishra.
No, the position has not been served.
Give it. You have received the case diary, na?
Yes, case diary is there.
Land and
that
Council
is
for
at
the
Annexure 3. Annexure 3.
Annexure 3.
Running page 78 to 18.
So say extrajudicial confession of witness mane heleni.
Yes, my lord. One of the witness, that is Shama Mundari.
Sama Mundari out of Jadumani Mundari.
Shama Mundari has been examined.
Examined as PW?
PW 4, my lord. That is at running page 83.
He has not supported the prosecution.
Yes,
Jadumani?
Jadumani has not been examined.
And the most important material is that you had buried that dead body, and from that position the dead body was on the basis of your statement recorded under section 27.
Yes.
So that is a very clinching material against you.
Those 2 independent witnesses to the discovery of the body perhaps have also been not examined.
No, that one has been examined.
One has been examined.
Samo Mundari has been examined. He has just given you the deposition copy.
Yes, it is there, Lordship.
And the other man has not been examined. That is mentioned his name. That is Jadumani Mundari.
Until 2000.
Lords, there Jadumani Mundari and the other persons, they are the witnesses to the extrajudicial confession, Lords. The Sukkalai Mandari and Chaman Mandari, they have also been witnesses to the
27
statement, Lordship.
They have not yet been examined.
Yes, Suge Mundari has been examined.
What he has stated?
That he is the informant, my lord. Suge Mundari.
Suge Mundari, देखियो कितने नंबर को जंदी साकी?
Page 86.
86.
PW 6.
P right. So we came to know that so has missing. We searched for her, could not trace when I
stated.
Identified the spot and himself exhumed the body.
But in the cross, my lord. And in cross, he has stated that I have not stated to the police in the 4th paragraph, my lord. I have not stated to the police that on being confronted by me and my husband, the accused Nepal disclosed that he had committed murder of somebody, and that he also identified the spot, and that he himself exhumed the body of somebody, and that the dead body has decomposed. It is not a fact that it has been mentioned in column 9 of the inquest report that we exhumed dead body of somebody and the accused Nepal has not disclosed before me.
You are in custody since 2019.
Yes, my lord.
All right. Heard the learned counsel for the petition, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 21/7/2019. And it's a case based on 2019 or 20?
20 your lordship.
2020, sorry. 2020.
Case টা হଉଛି 20 ର କୋଉଟା?
Yes, my lord.
21/7/2020. And he has been charged under section 302(201) of the Indian Penal Code. Earlier, when the petitioner approached this court for bail in BLAPL number 3131 of 2021, same was rejected as per order dated 7/9/2021. However, liberty was granted to the petitioner to renew the prayer for bail after examination of the material witnesses in the trial court. Learned counsel further submits that in the meantime, in the trial court, 7 witnesses have been examined, including some of the material witnesses, and no clinching material has common record against the petitioner, and therefore the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail and submitted that the informant Suge Mundari, who has been examined as PW6, stated that at the instance of the petitioner, the body of the deceased was exhumed and stop. Considering the submission made by the learned counsel for the respective parties, the nature of accusation against the petitioner, the nature of evidence adduced so far in the trial court, and since the petitioner has remained in custody for about 3 years and 5 months, I'm inclined to reconsider the prayer for bail and direct the petitioner to be released on bail allowed. Yes.
Item 65.
May I please, Your Lordship?
Yes, Mr. Roy,
Yes, there is there.
My lords. Case under section 20B2C. This is the, since 3rd January 2020, my lords.
Agur jaitire interim bail.
Yes, in 9405 of 21 3 months, and in 8835 of 22 3 months.
Last time kebe jaitile?
8835 of 22, my lords. That is order dated 29 March 23.
Surrender kole?
Yes.
Thik samare?
My lords. And out of 21 charge-sheeted witness, 9 witnesses have been examined. That was reflected in the rejection order, my lord, at page 14.
So what is your instruction about the this period which he was released on bail, whether he has misutilized his liberty or
I'll take that instruction.
He was released twice for 3 months and 3 months.
My lords.
So take that instruction, we'll take up this matter.
Lordship.
The learned counsel for the petitioner has submitted that twice the petitioner has been granted interim bail for 3 months. And after availing the same, he surrendered at right time. Let the learned counsel for the state obtain instruction whether there is any allegation against the petitioner to have wanted a sound to have misutilized the liberty while on interim bail or not. Put up this matter on such and such date. In the meantime, status report be called for. Yes.
Page 14 it was mentioned, my lords.
Status report. And whether misutilized. Yes.
Item 66.
May I please, Your My lord, last occasion, Your Lordship had called for the
Lordship.
petition 147, 148, 294, 341, 324.
Wait. Case diary achi?
No, case diary is not yet.
Get it.
Two
ଆସିବ?
Two connected matter is there. Two connected matter is there.
List ଆଜି ଅଛି?
Connected matter brief that has been disposed of, Lords. We are trying to find it, but we could not find it.
No,
So
get it.
I'll get it, Lords.
Which police station?
Lords,
Surjanagar.
Kabi Surjanagar.
Kabi Surjanagar.
Okay. Next.
Item 68.
Yes, next, Mr. Kuntia.
Petition custody,
876.
custody from 30/8/2020, my lord.
Mr. Tripathi.
filed an comprehensive affidavit.
So you have received the case diary. So comprehensive affidavit. How many cases are there against you?
13.
13. सब गुड़ाक 394,
Yes, sir.
399, 402,
Habitual offender.
395 also. So you have expertise in one branch, that is डकैती, robbery, चोरी, ये सब एथरे 13टा केस है ना 2000 आपण 2018 रु आपनकर एक्सपीरियंस अछि
My lord, in this case, actually, police implicated my name in several cases for which I am actually aware.
काई पुलिस कर कोन आपन संगे कोन पई आ का पाइलेनी आपन पई पछर लागिला
सर गोडदिटा केस हेले पुलिस करता सर सुविधा ना 402 करे फिर 5 जन दरकार जहां ना
এই কেসটা 399 402 এইটা এগুটাକୁ ইজি করে দিয়ে যাই পারে बट आउ जोड़ाकर आइडेंटिफाई हेतिबे सब 394 395 केस रे सेगुड़ा कोन करा जिवो को केस रे बेल फेल हेलानी आपन करो
My lord, the mother is filed and mother has not much idea regarding this. I don't have that instruction how many
Is not reflected.
you have mentioned in your affidavit, comprehensive affidavit, that the petitioner has been released in some cases. That's a vague statement. Which case you have been released, and if you have been released, where is the bail order copy? These are all in bail orders of 2 to 3 police stations. So one is Saranpur, the other is Chandapur, and the
Saranakula.
Or Odoga.
Odoga, Saranakula.
So make specific assertion in which case you are being released on bail. Your client must be supposed to know about the same, and also collect the bail order and file so that we'll see that whether the statement is correct or not. That in some cases you have been released on bail. An additional affidavit has been filed wherein it is mentioned that in some cases the petitioner has been released on bail, but it is not mentioned which are those cases and when the bail was granted, and no bail order copy has also been annexed to the additional affidavit, the comprehensive affidavit. Since there are as many as 13 criminal antecedents against the petitioner, let the Land and Council for the petitioner file a better affidavit indicating as to which cases the petitioner has been released on bail, being supported by the bail order copies, giving copy thereof to the Land and Council for the state. Yes, next.
Item 80.
80 on the CD is not there.
Good as you are.
Eta Boriguma.
Good, sir.
Boriguma, Koraput.
Koraput.
Status report called for me, that is flag.
Status report ଅଛି ଆସି ଯାଉ ଇଏଟା so CD ଟା ଆସିବ ଏଟା ଜାନୁଆରୀ ରଖିଦିଅନ୍ତୁ
Item 81.
Yes, Mr. Pujari.
The CD required.
Who does you?
Mohana. Gajapati.
We'll get it by next week or after?
After vacation.
So next week आसो आगे 8-9 रो फाइल है
8-9 रो अच्छा status report मंगाई नहीं
ना
अच्छा status report हम मंगाई दियंतु आउ CD. Yes, next
ଅଛି
same
मोहना
status report ई same लोग को गोटे petition
आगे same
status report CD. Yes, next.
Item 83.
Please. By the 20B2C of the NDPS Act manner.
अच्छी केस डायरी अच्छी
83.
10382 of 2023.
Yes, case dear.
Yes.
Custody since 14/2/2022 manner.
Yes.
Charge sheet submitted on 8/8/2022.
Under section
20B2C of the NDPS Act, man. 20B2C and 25 of the NDPS Act.
25.
Man.
And
in this case, BLPL 4519 of 2022, your lordship had granted liberty and expedited the trial within a period of 6 months. Man.
What happened? What is the position now?
My lord, last occasion, I think a report has been called for your answer.
Thirteen charge sheet witnesses, 4 witnesses have been examined.
Right. Local person, my lord, interim jain.
How many cases are there against the petitioner?
CA has not come here.
Get the case, right?
My lord, he has no criminal antecedent.
All right, we'll see that. Peru the status report submitted by the Learned Session Judge cum Special Judge Malkangiri. Learned Counsel for the state seeks some time to produce the instruction about the criminal antecedent, if any, against the petitioner. Put up this matter on such and such date. Yes, next.
Oblige, lords.
Item 84.
My lord, petitioner is in custody from my lord.
CD is required, my lord. 302 case.
In my lord.
CD.
In the meantime,
I am appearing for the informant laws.
in the meantime, lordship please to enlarge the petitioner in interval twice in BLPL number 9619.
See your final to suna about the interim bill nahi. You have filed your VNAMA.
Lordship.
Where is that?
About 5 in the custody, my lord. In the meantime, the prosecution exam 32 and 8 witnesses are examined.
Give the copies to the state council also.
Already, my lord, I annex money bill application.
Yes, I have the PW5 is the eyewitness, my lord.
All right. So,
injured eyewitness, PW5 and 6.
Lordship, in this case, last occasion,
Kobinaik dealt a cutlery blow to the head of my father. Russia Naik dealt a sword blow on the head of my father.
Here on bail, my lord.
Vijay Naik assaulted by means of farsa on my father. And blood was oozing, so and so. Vijay Naik also assaulted on my head, for which I fell down sustaining bleeding injury. Accused Babuli, so and so, surrounded my. They are this name Babuli Naik, Bulla, Sauraj, Sanai, Sudarshan, and so on. Trinath Nath City Naik. Sorry, Sarat Naik. Sarat Naik achi. Grandfather Nityananda Naik attacked him by means of Tenga. Babuli Naik assaulted, he fell down. All the accused persons dealt kick blows. Accused Vijay Naik assaulted on the chest of swans.
Lordship, in BLAPL number 522 of 2022, your Lordship has granted them interim bail, Lordship. In that time, they have not surrendered in due time, Lordship. After 20 days, they have surrendered before the court below, Lordship. And in the meantime, they have threatened the informant lordship. Therefore, I have lost another FIR, by FIR number 105 of 2023 lordship. And in the meantime, they have also gained over the eyewitness, who is the Kasinath Naik lordship. And now the last occasion, the father of the Kasinath Naik also taken them in bail, lordship. And in the meantime, lordship, last occasion, I have also informed to the SP of the Noyagad regarding this matter, regarding threatening and not to come to the court premises and withdraw from this case. They have also threatened me, lordship, in the court premises.
Sharath Naik ya nare session judge deichanti. He was released on bail and he was supposed to surrender on 17/8/2022, but he did not surrender on that day and surrendered on 13/9/2022. ତେଣୁ ପାଖାପାଖି ମାସେ ପରେ ଅଧିକା ସେ ସରେଣ୍ଡର କଲା। ଇଏ ଗୋଟେ କଥା। ଦ୍ୱିତୀୟ କଥା ହଉଛି ଯୋଉ ଆଇ ୱିଟନେସ୍ ଟା ଏକ୍ସାମିନ୍ ହେଇଛି in the trial court, he is also an injured eyewitness, PW5. So what he has stated only that he was there in that surrounded the so and so, but specific assault जो deceased ना कौन
नित्यानंद नायक
नित्यानंद नायक ପାଇଁ ଏଟା ହଉଛି ନିତ୍ୟାନନ୍ଦ ନାୟକ PW5 ର କଣ ହବ is the grandfather। अच्छा ସେ जो grandfather ହଉଛି ସେ କହୁଛି accused so and so including this petitioner surrounded my grandfather Nityananda Naik, attacked him by means of thenga. Babuli Naik assaulted on the head of by means of thenga. He fell down and all the accused persons dealt kick blows, and Vijay Naik assaulted on the chest by means of farsa. Bobby Naik assaulted so and so. Yes, so anybody has been released on bail in this case?
All the persons are released on bail except the three petitioners. Some are released on bail, and my lordship also allow one Hussain Naik is on bail and by the BLPL number.
Let us come to that evidence. Let us check that against whom specific overt act has been given.
PW6 में
6 is the informant.
Informant.
नहीं ए witness भी तो कोई ना
ये तो injured eye witness and PW6 also.
ଏଇ ମାନେ ସେ କହୁଛି ଏମାନେ ଘେରି ଗଲେ ନିତ୍ୟାନନ୍ଦକୁ
ତାପରେ ଠେଙ୍ଗାରେ ବାଡେଇଲେ
ତାପରେ ନାଇଁ ସମସ୍ତେ ନୁହେଁ ସେ କହୁଛି they were assaulted, they attacked him by ଠେଙ୍ଗା କହୁଛନ୍ତି ତାପରେ ସେ କହିଲା Babuli Naik assaulted on his head by means of thenga and he fell down. Then other accused persons dealt kick blows. ହେଲା ଆଉ ତାପରେ Vijay Naik assaulted on his chest by means the backside of the farsa. এটা হচ্ছে specific so far as এইটা দিয়ে দে এটা কাটো এই লাইনটা ତାପରେ PW6 କଣ କହିଲା let us see Mr. Tripathi
page 33
ହଁ
accused Vijay Naik assaulted to the head of my son by means of a farsa resulting in his
ନାଇଁ deceased କୁ confine
ତାପରଟା when my father protested,
father mane se
father to Nityananda decision.
हाँ
When my father protested, Babuli Naik, Bulu Naik, Kulamani Naik, Sonei Naik,
Sonei hochi gote
petitioner,
petitioner.
Suresana Naik, and Sarat Naik, all three are petitioners. And Sofan Naik assaulted him by Thenga, resulting which he fell on the ground, and the accused person thereafter assaulted him by their feet. तो विजय नारे अच्छी था हर्षा
So you have been named by the eyewitnesses PW. Two eyewitnesses at least named you, PW5 and PW6. So they have stated that you assaulted them by means of lathi. And not only that, the one of the accused, he was granted interim bail, that is Sarat Naik. He has not complied with the order of this court and surrendered after. What is the date of custody?
Date of custody মানে 23/9/2018.
Are the learned counsel for the petitioner, learned counsel for the state? The learned counsel for the petitioner submitted that the petitioners are in judicial custody since 23/9/2018. And in the meantime, trial has commenced and some witnesses, including eyewitnesses, have been examined in the trial court. And they have stated in an omnibus manner against the petitioners. And therefore, the bail application of the petitioners may be favorably considered. And some of the co-accused persons have also been released on bail. Learned counsel for the state, on the other hand, opposed the prayer for bail and placed the evidence of PW 5, Suman Kanto Naik, and PW 6, Muralidhar Naik, the informant in the case. And the learned counsel for the informant also opposed the prayer for bail and submitted that threat has been given to the informant and other witnesses by the accused persons, for which another case was instituted. Period the status report submitted by the London Trial Court, which is dated 30/8/2023, from which it appears that the petitioner Sarat Naik was released on interim bail as per the order of this court. And there was a direction to surrender on 17/8/2022, but he did not surrender on 17/8/2022, rather surrender on 13/9/2022. And it is further mentioned that out of 21 charge sheet witnesses, 7 witnesses have already been examined. Considering the submission made by the learned counsel for the respective parties, the period of detention of the petitioners, number 2 and 3, Sudarshan Naik and Sunay Naik, and the slow progress of the trial, I am inclined to release them on bail. So far as Sarat Naik is concerned, since he has flouted the terms and condition of the bail order, interim bail order, I am not inclined him to release bail. I was rejected, yes. So P2 and P3 released, P1 rejected. Yes, next.
Item 85.
Item 85 on behalf of Mr. Jain Panda, I may be permitted. But there are two sub-items. The first item, Lord's BLAPL 10583.
CD available?
Yes, madam.
Your Lordship had directed me to file a criminal antecedent. Report, my Lords, it could not be filed in the first matter because of the fact that the relations of the petitioner could not come on time. Your Lordship may grant me time in that matter, first matter. In the second matter, it was directed that the state to obtain criminal antecedents, if any.
So have you obtained, Mr. Tripathi?
In BLAPL 10670. My basis of implication is a confessional statement.
The pratham ta lekho. BLAPL number 10583 of 2023. Mr. Sudipto Panda, Land Council, appearing for the petitioner, submitted that though he was supposed to file, no, there was no such direction to file. It was the State Council was asked to obtain instruction.
Well, there are some antecedents against the petitioner in the first matter.
All right, but he has not obtained.
Comprehensive affidavit needs to be filed, my lord.
So, khali lekhi diyantu that comprehensive affidavit not filed. Where is that order?
There is no order. Your Lordship had verbally asked me. Probably it is not reflected.
Is it that 24/11/2023 रे तो किसी लिखा ही नहीं फूड फाइल लिखि देला से देख तापर आउ किछि ऑर्डर हिछि कि 26/11 परे नहीं तो
तापर आउ नहीं किछि.
All right, the Land Council for the state seeks some time to further time with them to obtain the instruction about the criminal antecedent, and the Land Council for the petitioner also submitted that he will file comprehensive affidavit relating to the status of the criminal antecedent, if any, by the next date, giving copy to the Land Council for the state. Same order in the both the cases. Yes.
Grateful.
Item 86.
86 में हम page madam.
I mean, sub-item.
Yes, yes. We'll take up this. Case diary is it?
Your Lordship just called for the status report.
86.
It is. Your Lordship was sub-item. Your Lordship was pleased to grant me interim bail on 20 January 2023. Considering the fact of his detention and also the fact that.
Yes, Mr. Tripathi.
Yes, it is there.
Also considering the fact, your Lordship kind of glance to the order dated 20/21/2023 in BLAPL 1127 of 2022.
Eyewitness account of Jitun alias Jitendra Samal and manner so on. So, what is the position now?
He was examined.
Yes.
He was examined and he implicated 3 persons, Jitu, Rilu and Silu. And Silu has been granted anticipatory bail by the Honorable Court. And considering that fact, your Lordship was pleased to grant interim bail for a period of 3 months. And if thereafter he surrender and move for bail. Once again before the court below, the rejection now before Lordship.
No. The status report indicate that out of 25 charge sheet witnesses, 5 witnesses have been examined.
At that time, there are that eyewitness PW4 Jitun Samal, that he is the only eyewitness for.
Where is the deposition copy? Have you supplied to the State Council?
Earlier it was.
Earlier se file golani where the Land Council for the state petitioner peruse the status report submitted by the Land Trial Court, which indicates that out of 25 charge sheet witnesses, prosecution has examined 5 witnesses so far, and 2 witnesses have been declined. The Land Council for the petitioner submitted that he is having the deposition copies of all those 5 witnesses with him. Let him supply the deposition copies to the Land Council for the
only PW4. Yes,
say copy receive करंदनी certified copy. certified copy of the five witnesses. Yes.
Certified copy.
Put up matter after January. Yes, next. Don't receive any this copy from any council. Yes.
Item 87.
May I please yours. Madam, I am for the BLAPL number 10879 of 2023, madam.
So, have you received the case diary?
87. No, case diary is not available.
Court has you.
It has your Umar court.
There are two files.
I would find it.
आरटा देखिले connected file अछि नहीं दीटा के नहीं alright case diary पे रख दियो case diary और criminal antecedent
Yes, that was also called for the last.
yes sir
Next 721 వచ్చింది.
let it come will hear this item next item
Item 88.
May I please, your lordship? Offense under section 20B subclause 2C of the NDPS Act. I have been implicated in this case.
Wait, just let him.
I have been implicated in this case. Based on the statement of accused. I order dated 8/12/2023. This honorable directed to take the instruction regarding the criminal antecedent.
Achhi case diary, Mr. Tripathi?
Yes, my lord.
CD available?
Yes, my lord. CD.
Yes, make your submission now.
Madam, the accused person has been implicated in this case based on the statement of the co-accused. And the co-accused, whose statement I have been implicated in this case, he has been acquitted.
10913 of 2023. So, Mr. Tripathi, as it appears, on the last date, it was not disputed that the only material is the confessional statement of co-accused. But you took time to obtain instruction if there are any criminal antecedent against the petitioner.
Yes, that has come. No criminal antecedent.
Heard the learned counsel for the petitioner, learned counsel for the state. Considering the submission made by the learned counsel for the petitioner, that the petitioner is in judicial custody since 10/9/2023 and only material available against the petitioner is the confessional statement of co-accused before police and for the submission that the said co-accused has already been acquitted in the trial court and after hearing the learned counsel for the state to on verification of the case diary submits that there are no criminal antecedent against the petitioner. I am inclined to release the petitioner on bail allowed.
Item 89.
Wait, please, your lordship. Item 89, my lord.
Yes.
My lord.
CD available?
Yes, my lord.
CD available. My lord. My lord, custody since 27/9/2018, your lordship.
Wait, just a minute. BLAPL 10931
of
2023. Netrananda Maji.
Alias Niku Maji.
So, what is the date of custody?
My lord, 27/9/2018. 27/9/2018.
Kete thora ashanti?
Earlier, one bail application disposed by BLPL number 5361 of 2021.
Yeah, just a minute. So, this is your second bail application?
My lord, this is second bail application.
So, what happened in 5361 of 21?
5361 disposed of, your lordship.
No, dispose of the what order has been passed?
Only
what the copy?
Yes, my lord, I have the copy. Considering the submission advance on behalf of the parties and taking into consideration. No, my lord, I have not appended the bail rejection order, my lord.
No, it's all right, but what has happened? The bail application was rejected.
Rejected, simply rejected, no liberty granted, your lordship.
Why it was rejected? On what ground?
Because the present accused is the principal accused in this murder case, your lordship.
Okay, that was rejected when? What is the date?
The date is 19/9/2022.
So what development has been made in the meantime after the rejection?
Till 19/9/2022, my lord, no trial has been commenced. After 19/9/2022, 12 charge-sheeted witnesses examined, my lord.
So have you filed the deposition copies?
My lord. Annexer 2 series is the deposition copies.
Is it available with you, Mr.
Yes,
Tripathi?
yes.
So, so which witness has stated against you out of these 12?
PW1, PW6, PW7, and PW11.
What they have stated against you?
My lord, PW1 and PW11. PW11 is the another injured. PW number 1 is the complainant, my lord. They stated the principal accused stabbed the deceased. Also,
what is the name of the deceased?
Balram Hathi, my lord.
So that line which you said that another
PW1 last line.
By the time the accused persons Bablu, Tiku, Afsal and Dipu
told the
Niku Maji.
Got hold of the hands of the elder brother Balaram. Balaram is the deceased, right?
Yes. And accused this.
Niku, acha. Pierced a knife on the chest of my. So you are that person who committed, pierced that knife on the chest of the and other person. So the main allegation is against you.
My lord, the main allegation is against me, my lord. Your lordship may kindly peruse the cross examinations, my lord.
Cross examination, we arguing at the time of during at the argument stage. You argue. I am not going to enter into the detail of appreciation of evidence while considering the bail application.
But my lord, your lordship may kindly consider 31 number of charge-sheeted witnesses are there, my lord. Since 19/9/2022, no witnesses were examined. After that, only 12 witnesses are examined, my lord.
Custody for last 4 years.
5 years, 3 months, my lord.
2 years or 5 years.
3 months only, my lord.
How many CA are there, Mr. Criminal Antecedent?
As per instruction received, my lord, there is no criminal antecedent. This is the first.
Are the learned counsel for the petitioner and counsel for the state? Considering the submission made by the learned counsel for the petitioner, that the petitioner is in judicial custody since 27/9/2018, and in the trial court, 12 witnesses have already been examined. 12 na 11? 12 witnesses have been examined, and at this stage there is no chance of tampering with the evidence. And after hearing the learned counsel for the state who placed the evidence of eyewitness Debo Jani Hatti bracket PW1 and stated that the petitioner has given the fatal blow to the accused.
My lord, Debo Hari
Hatti bracket PW1 stated that we given the fatal blow to the accused. Considering the period of detention of the petitioner in judicial custody and slow progress of the trial, I am inclined to release the petitioner on bail allowed.
Grateful much.
Lord, I am addressing from Dhenkanal VCO.
Yes.
Item 90, my lord.
Item 90.
Yes, argue.
Status report was called for by the lordship